Ladies and gentlemen, good morning. Thank you to have a seat. Yeah, ladies and gentlemen, good morning. Welcome to plenary session 5, rule of law, including independence of the judiciary, right to a fair trial, and democratic lawmaking. OSCE participating states have affirmed the importance of an independent and impartial judiciary, the right to fair and public hearing, and access to legal representation. These are fundamental pillars of democratic societies governed by the rule of law. Upholding these principles safeguards human rights and legal certainty and promotes accountability and transparency and strengthens public trust in justice systems. 50 years after the adoption of the Helsinki Final Act, persistent and emerging challenges affect rule of law and justice systems across the OSCE region. This session will reflect on positive examples of effective judicial functioning, while also addressing concerns such as political interference, weakened institutional checks and balances, corruption, and barriers to access to justice and a fair trial. Participants are invited to share recommendations to foster more independent, fair, inclusive, and transparent justice systems and lawmaking processes. Discussions will also explore how civil society and the legal profession can be empowered to respond to threats against judicial independence, support democratic lawmaking, and reinforce trust, accountability, and democratic resilience. Ladies and gentlemen, we will have introductory remarks by a very distinguished panel. We have Judge Diana Kovacheva, Judge of the European Court of Human Rights. We have Mrs. Tuija Brax, Director of the Rule of Law Center at the University of Helsinki, and we have Judge Maria Rosaria Giulielmi, President of the Association Magistrat Européen pour la Démocratie et les Libertés. Ladies and gentlemen, we go in medias res, and I'd like to present Judge Diana Kovacheva, Judge at the European Court of Human Rights, elected in April 2024. Judge Kovacheva served as the National Ombudsperson of the Republic of Bulgaria from 2019 to 2024, and previously as Deputy Ombudsperson between 2016 and 2019. Alongside her public service, she has built an extensive academic career as Professor of International Law and International Relations at the Bulgarian Academy of Sciences and Sofia University, where she has taught since 2013. Earlier in her career, she was Minister of Justice of Bulgaria from 2011 to 2013 and Executive Director and Legal Advisor at Transparency International Bulgaria from 2002 to 2011. Judge, the floor is yours.
Thank you, Your Excellency, distinguished ladies and gentlemen. I'm going to talk today about the independence of judges, and I will start by saying that judicial independence is, of course, one of the cornerstones of democratic society, and we could say that it is considered as one of the general principles of law recognized by civilized nations. History has shown us, as time and again, that justice cannot flourish where judges are subject to political control, intimidation, or arbitrary removal. Importantly, the independence is not a privilege of the judges themselves. It is a right of every person who seeks justice, and it safeguards the rule of law itself. The European Court of Human Rights has played a decisive role in shaping this principle. In its landmark decision from 1975, the judgment Godler versus the United Kingdom, the European Court of Human Rights used the concept of the rule of law, basing its interpretation on Article 6 of the Convention and on the reference to the rule of law in the preamble of the European Convention on Human Rights. Later, in the case Astrason versus Ireland, it made clear that even seemingly technical flaws in the appointment of judges can undermine confidence in justice and breach Article 6. These rulings show that judicial independence is not abstract. It is essential to protecting individual rights. Yet, independence is not absolute. As the Venice Commission often reminds us, it must coexist with accountability. Judges must be subject to ethical standards and disciplinary measures, but those tools must never be misused to punish judges for unpopular decisions or exert political pressure. In the Albanian case, the court explained that independence is not a personal privilege, but an instrument to protect the judiciary's integrity. At the institutional level, cases like Jeda versus Poland remind us how reforms to judicial councils can dangerously weaken the separation of powers. So I would like to talk today about the practical framework for assessing whether a judicial body is independent given to us by the European Court of Human Rights in its practice. So the first one is the manner of appointment. Judges may be appointed by parliament or government, and this is not inherently problematic. What matters is, once appointed, they should be free from undue influence and not selected to serve a political agenda. For example, in Nin Hansen versus Denmark, the court dismissed this argument that parliamentary appointment of lay judges compromised their independence. Similarly, in Filippini versus San Marco, the court held that election by parliament was not inherently problematic as long as judges once appointed exercised their functions independently. Second, the duration of tenure and irremovability. Judges cannot be dependent on those who appoint them. Renewable short terms can make judges vulnerable, while security of tenure strengthens impartiality. In Inkal versus Turkey, the court expressed concern that renewable four-year mandates for judges at the national security courts could make them dependent on the appointing authority and thus compromise their independence. Third, the guarantees against outside pressure. Independence must be real, not just formal. We have seen violations where politicians intervened in cases or undermining both the appearance and the reality of impartial justice. In Campbell and Fell versus the UK, the court stressed that judges must be shielded from premature removal by legislative acts. Such protection is essential to maintaining the appearance and reality of independence. In Sovonstraf's Auto Holding versus Ukraine, the court found a violation of Article 6, where the president and other high-ranking officials intervened in ongoing proceedings, undermining both the reality and the perception of independence. Likewise, in Kinski versus the Czech Republic, public statements by politicians seeking to district a litigant were found to create a negative atmosphere incompatible with the notion of independent tribunal. Last but not least, maybe one of the most important, appearance of independence. As the court famously stated in the Kuber versus Belgium and also in the case Delacourt versus Belgium in 1970, justice must not only be done, it must also be seen to be done. Public confidence in the courts is essential for the legitimacy of the judiciary, and appearances therefore matter greatly for the integrity. In Maurice versus France, the court stressed that the decisive question is not merely the litigant's perception, but whether the perception is objectively justified. These principles are more urgent today than ever. Across Europe, we see political pressure on the judiciary taking many forms: reforms that restructure courts or shorten judicial mandates, narratives that portray judges as enemies of the people, and media campaigns that erode trust in judicial institutions. Such developments remind us that judicial independence is never guaranteed. It must be protected every day. Even the European Court on Human Rights has been under political pressure recently. Ladies and gentlemen, judicial independence is not the concern of judges alone. It is a collective achievement and the collective responsibility of the judiciary, of the legal profession, of scholars and society at large. Safeguards such as judicial councils, transparent appointment procedures and fair disciplinary systems must be designed to protect the courts from political interference while ensuring accountability. Let us treat judicial independence not as a privilege, but as a public trust. Our role is to defend these safeguards, to explain their importance to the public, and to remain vigilant against threats to independence. Only then can courts fulfill their essential role as guardians of the rule of law. Thank you very much for the attention.
Thank you very much for your interesting intervention and for promoting the independence of the judiciary. Ladies and gentlemen, let me now introduce Mrs. Tuija Brax, Director of the Rule of Law Center at the University of Helsinki. Mrs. Brax is a Finnish politician and former Minister of Justice. She is a member of Finnish Parliament representing the Green League. She was first elected to the Parliament in 1995. She has been the Minister of Justice in Matti Vanhanen's second cabinet and Mari Kiviniemi's cabinet. She has also been a member of the Helsinki City Council from 1993, and she is active in various professional sport organizations. Mrs. Brax has a master's degree in law from the University of Helsinki. She also served as the chair of the Legal Affairs Committee in the Finnish Parliament. The floor is yours.
Thank you, Honourable Moderator. The first speaker and also the third speaker are going to speak very well about the independence of judiciary. So I will concentrate on a little bit different topics concerning mainly of evidence-based decision-making as a part of the rule of law. But before that, let me first draw you, hopefully you can sort of follow my signatures in the air, a triangle that the rule of law consists of. For example, if we look at the Venice Commission's sort of a description or the checklist of the rule of law, you have a triangle where the corners consist of human rights, democracy, and the rule of law. You cannot have any of these without the other two. And then at our center, we always draw sort of a foundation for this pyramid that it doesn't really hold unless there is a strong civil society, strong and free media, and of course, being from the university, but also for other reasons, strong and independent academia. And now if we look at the threat to this, all of the pictures, I would name corruption. That was also pointed out already at the beginning of this session. We see nowadays in countries where there is a decline of the rule of law, in most of the cases the decline when coming to fighting corruption is at least as bad as the decline of the rule of law. It sometimes suffocates the work of the political decision-making, sometimes corruption takes over the media, sometimes even NGOs are struck by it. In some of the worst cases, it can also harm the judiciary, and that's why the vetting case, you just heard the reference to in Albania, but there are now vettings going on also in Ukraine and Moldova, is a crucial thing that we need to have methods for attacking corruption. The former leader of the US aid, Samantha Powell, referred a few years ago corruption being actually the threat number one to the security, not only to the security of her own country, but to the security of the whole globe. So being here today with this security conference, I would point out that there are good reasons to remember what Samantha Powell said a few years ago. So it is a common threat to all parts of the triangle and also of the foundations. And from that perspective, a common denominator for all these parts would be that's my main message, is evidence-based decision-making. The fact that the society is based on decisions that are done in transparent processes that can be foreseen, that are inclusive, and that takes into account the need for getting all the possible information and also points of views in the same platform and evaluate them and then openly state for what reason this or that law or decision, or when it comes to groundings of the courts, then that you can see in the groundings for what reasons this is sort of weighed heavier than the other one is really crucial. And right now we have a lot of data that this evidence-based decision-making is also under attack. You don't have evidence-based decision-making unless you really honor the processes that sometimes take time, that you have processes where there is time enough to give your comments, that there is somebody who really concentrates on all the angles of the law in question or the decision in question, or that you really also appreciate the knowledge coming from independent academia, from different expert groups, and that you don't label them for no reason to be, for example, too liberal or leftist. Or if they are that, then of course, but in some of the cases there seems to be a trend that no matter what the science or the academia is saying from the populistic parts, it's labeled somehow being to the wrong side politically. Even nowadays in medical or biological cases, just the latest debate on vaccination is here, that the burden of proof is, it doesn't comply anymore. So from that perspective, I was a few weeks ago chairing an occasion of OECD around impact assessment, and that they had data that in several countries the use of impact assessments has been weakened lately. And I asked the audience that, do you think that if I would go in the Senate Square of Helsinki and try to get people alongside with me to demonstrate that we don't accept it, that these processes are the safeguardians of the rule of law, everybody agreed with me that no, I would stand there alone. And so my message to this audience is that I think we have to sharpen our argumentation and lifting up it a little bit higher when we talk about the threats to the rule of law, that these processes and forums and methods of safeguarding evidence-based decision-making and require groundings from the court so that they would be at least at the level that you would pass with the lowest degree in the law faculty, your exam, should be taken more seriously. We should discuss it more thoroughly, and also when describing, for example, this is now an EU matter, in this yearly report of rule of law in countries and candidate countries, I think that this evidence-based decision-making should be lifted a little more up there so that we can see how this is all linked together. So with these words, I would say that that's the reason why we work, for example, right now together with Uzbekistan in providing a process for evidence-based decision-making, impact assessment, regulatories, for example, for people with disabled persons, and in Ukraine with the Minister of Justice to create a transparent online platform that needs to be used in all the legislation, not only with the currently 20% of the legislation going to the parliament, so that the very basis of the rule of law are safeguarded also from that angle. Thank you.
Thank you very much, Mrs. Parks, also for reminding us about the triangle of rule of law, the dangers emanating from corruption, and the evidence-based decision-making, and hopefully you will not stand alone at the Helsinki Square then, in the end. Ladies and gentlemen, may I now introduce you our third speaker, Judge Maria Rosaria Giulielmi, President of the Association Magistrats Européens pour la Démocratie et les Libertés. Judge Giulielmi is an Italian magistrate and the president of this association, a European association of judges and prosecutors dedicated to the promotion of judicial independence, democracy, and the rule of law. She previously served as Secretary of Magistratura Democratica, the Italian Association of Judges committed to advancing constitutional values, equality, and judicial autonomy. Mrs. Giulielmi is widely recognized for her expertise and commitment to safeguarding the rule of law in Europe. The floor is yours.
Thank you very much. Ladies and gentlemen, esteemed colleagues and participants, it is a great honor to be here and to have the opportunity to share with you MEDAR's perspective on the crucial issues addressed in this session. Since its establishment, MEDEL has been monitoring rule of law developments at the national level in Europe and beyond, with a focus on the independence of the judiciary. MEDEL has made us aware that there are no reversible achievements for democracy and fundamental rights. We witnessed dramatic events such as the arrests and dismissals of thousands of, among others, magistrates, lawyers, jurists after the attempt coup d'etat in Turkey, and the association Yarsav, member of MEDEL, was disbanded. Its president, Murat Aslan, winner of the Council of Europe Václav Havel Prize in 2017 for his commitment to justice and human rights, was arrested in 2016 and is still detained, despite the systemic violations unveiled by the landmark ruling of the Strasbourg Court on conviction for terrorism offenses. We are witnessing an increasingly disruptive rule of law backsliding even within the European Union. The way has been paved by member states where various ways of faking constitutionalism, as Professor Müller said, and reforms bearing as a manifesto the necessity to bring the judicial system back under democratic control, rapidly provided executive power with a firm grip on courts and other key institutions such as public prosecutor offices, councils for the judiciary, constitutional courts. All these despite the development of the rule of law framework and toolbox aimed at protecting the European Union founding values. MEDEL has made us aware of how complex the challenges to the rule of law have become and why the stakes are so high. I will mention three different dimensions. Attacks on judicial independence are part of a broader project, where curbing checks and balances is only a first step, eventually functional to regressive policies affecting individual and collective rights and freedoms, and the role of civil society, a project of a new order, no longer based on equality in rights and dignity, but rather on exclusion and identity. The most evident examples of this development are the attacks launched against judges dealing with migration cases, following their decisions which, although they refer to supranational sources to protect individuals, are deemed unlawful since they are not in line with restrictive national policies and national interests. All this in a context where criminalization of support to migrants and humanitarian aid is now a global phenomenon, and where at the national level a variety of legal instruments is designed to hinder the work of NGOs, such as those rescuing migrants at sea. The lawmaking process underlying these developments is also often per se a cause of concern due to the proliferation of criminal offenses, a security-centered approach, and the use of accelerated procedures that bypass ordinary public scrutiny and minimize the role of parliaments. As a further dimension, we can observe that the attack against the judiciary is becoming a structural feature of the current global wave of autocratization and a main target, especially in the early phase of this process, as observed by the 2025 report of Varieties of Democracy Institute. A regime transition necessarily requires the rule of law is bent in favor of aspiring autocrats. In this perspective, the attack includes several subcomponents: an increasing intolerance towards the role of impartial guarantee of the fundamental right of the judiciary, reforms supported by aggressive media campaigns, led also by high-profile politicians, producing a distorting mirror image of the judiciary and undermining citizens' trust in the justice system. Populist rhetoric that denies democratic legitimacy of the judiciary by accusing unelected judges and prosecutors to play a political role against the interests and the will of the people. The attempt to limit, in the name of the impartiality and political neutrality of the judiciary, the freedom of speech and associations of judges and prosecutors. The case law of the Strasbourg Court on Article 10 of the Convention in relation to magistrates clearly shows the magnitude of the attack on these rights in the context of democratic regression. Eventually, we must consider that after more than a decade of democratic decline in Europe, the risk of disintegration of its legal order based on the rule of law is now a real one. Clear indicators in this sense are the systemic violations of European courts' rulings, which national authorities in some contexts can carry out even through judiciaries that are no longer independent, and the reforms implemented to prevent judges, also under the pressure of disciplinary sanctions, from using instruments such as preliminary rulings that serve to guarantee the primacy of European law and supranational sources. Medell made us fully aware that our common values can be overturned any time, and the current complex scenario for the rule of law has been further and seriously exacerbated by the globalization of attacks on democracy, international law, international humanitarian law, supranational judicial institutions such as the International Criminal Court, against the backdrop of escalating atrocities, war crimes, and mass human rights violations that we believed we would never see again. We have never been so close to the risk of destroying what the international community has painstakingly built over decades to prevent all this, to ensure peace and secure justice for victims. And given the scale of these challenges, today's conference is a precious opportunity to share our views on how to support the resilience of democracy and to reaffirm our commitment to defending fundamental rights and all our common values. Thank you very much for your attention.
Thank you very much for your contribution. Also, let's say your early warning that might not be that early anymore about the fragility and interdependence of democracy, rule of law, and the independence of judiciary. Thank you very much. Ladies and gentlemen, now before we come to the interventions from the plenary, let me just remind you of a few rules of the game. When given the floor, please introduce yourself, give your name and the organization you represent. You may only take the floor on behalf of the organization under which you have registered to attend this conference, and please also behind the name tags of the participating states, there can only sit representatives of that participating state that is indicated by the name tag. The speaking time is limited to 3 minutes. Please keep your contributions therefore brief and on the topic. To facilitate the work of interpreters, speak clearly and slowly and upload the text of your speech to the portal before you speak. The proceedings should be held in a respectful manner and in line with the code of conduct of this conference. All conference participants may submit written documents online via the conference platform, where they will be made available to all registered participants. Delegations of OSCE participating states may exercise their right of reply regarding any statement made by another participant in line with the meeting rules. Rights of reply must be announced at the head table during the session and then submitted in writing online to the conference platform. Here, I may say that yesterday, after plenary 4, we received notification of 2 rights of reply being submitted, one from the United Kingdom and one from Turkey. Any registered participant wishing to raise a procedural issue will be able to do so directly with representatives of the chair at the head table and not from the floor, not from the floor. All meeting rules and the code of conduct are published at the event website and apply to all events held at the conference, including the plenary sessions, side events, and other areas of the event. Ladies and gentlemen, now I'd like to come to our first speaker, and this is the political opposition movement Erkin Uzbekistan. Please, the floor is yours.
Спасибо, господин модератор.
Thank you very much, Mr. Moderator. On February 2025, Uzbek secret services arrested a colonel of the military intelligence of Uzbekistan, Valija Rakhmanov. He revealed the mass theft of the state resources. Over 1 year, he was detained in a solitary confinement. He was deprived of justice in court. The regime of Mirziyoyev isolated Rakhmanov and charged him of espionage for USA and United Nations. The court convicted Rakhmanov to 16 years of imprisonment for state treason. Later, Rakhmanov was charged for revealing state secrets, and his term of imprisonment was increased to 17 years. We informed the State Department, the Embassy of the United States, and mission of the United Nations in Tashkent that Uzbek state blames them for espionage. However, the United States and the United Nations did not reply to these accusations. In Washington, the Ministry of Defense of United States and Uzbekistan signed the agreement on cooperation. Later, the documents concerning military cooperation between United States and Uzbekistan leaked to the public. Information provided by United States to Uzbekistan is now in the hand of force. I would like to appeal to USA so that the State Department makes an official statement about Mirziyoyev's regime, which harms the cooperation between the two countries. We appeal to stop cooperation with the criminal regime of Mirziyoyev.
This is the delegation of Serbia.
Thank you very much, Mr. Chair. Esteemed colleagues, good morning. I will try to make an overview of all the activities that the Republic of Serbia has made in order to strengthen the independence of judiciary in the last couple of years. We started back in 2022 with the constitutional amendments. Following the positive opinion on the Venice Commission, the Parliament adopted the constitutional amendments, and the main goal was to actually strengthen the independence of judges and autonomy of the public prosecutors in Serbia. After that, we have adopted a set of judicial laws, 5 laws: law on judges, law on public prosecutors, 2 laws on High Judicial and High Prosecutorial Council, and the law on organization of courts, and the whole aspect of election of judges and public prosecutor was changed. Long story short, the main goals were to exclude the parliament, and this is the huge step, the biggest one, to exclude the parliament and the executive power in the process, from the process of election of judges. So the process of proposing the list of judges and the election of judges is only made by the High Judicial Council. The same is with the High Prosecutorial Council. The only difference is that the Minister of Justice is not longer a member of the High Judicial Council, but it is a member, ex officio member of the High Prosecutorial Council. The only law which is to be adopted in accordance with the constitutional amendments is the law on Judicial Academy. We expect the law to be adopted this autumn. And in accordance with the provisions for which we have also been provided with a positive opinion on the Venice Commission, the Judicial Academy is to be the single entry point in judiciary. Generally, when we speak about democratic lawmaking, I have to say that I will just divide the process into the three pillars. The first one is the pre-consultative process, where we actually invite all the interested parties to provide us with their comments and initiatives before even we establish the working group. Establishing of the working group is always include the membership of the civil society organizations from the EU National Convention acting in this specific field the law is to cover. And also the third pillar would be, after the work of the working group, the public debate process, which is also followed mostly by roundtables organized in different appellate courts in the Republic of Serbia, where everybody could participate and provide their comments and interventions. This was also seen by the European Commission and recognized in the progress report on Serbia for Chapter 23, where they stated that those processes are comprehensive and inclusive ones, and this is how we will continue. The practical implementation of the law is yet to be measured. Thank you very much.
Thank you very much. Next one is the Organization for Social Welfare of Citizens Public Union. The floor is yours.
Thank you, Madam Moderator. My name is Nadia Rahimli. I am a representative Deputy Chair for Social Welfare of Citizens Public Union. In this plenary session topic, rule of law, I would like to briefly touch upon all three subtopics: independence of judiciary, right to a fair trial, and democratic lawmaking in the context of my country, Azerbaijan. Let me start with the democratic lawmaking process. Each country has its own legislative body, of course, but how the participation is applied here in our country. Firstly, right of legislative initiative, besides several governmental structures, also belongs to citizens. A number of citizens with the right to vote may have initiative of the legislation. Public participation is also considered in lawmaking process, like public hearing, so that law drafts registered in legislative branch of government are placed in the official website. Here, in a special section of the information is provided for public discussion, not only in lawmaking process, but also on draft legal acts prepared by central and local executive bodies. Public hearings and public discussions are held. This kind of public participation in lawmaking process develops through open debate and with the participation of civil society and with comprehensive legislation. When I move to the next topic of the session about the judiciary and fair trial, here I will touch the case which my colleagues, especially from Armenia, are discussing for several days here. It's about individuals whom my colleagues call just detainees, but indeed they are the ones who committed massive and atrocious crimes and are now in the front of a fair trial in Azerbaijan. They are accused of crimes such as against peace and humanity, war crimes, including the preparation and conduct of aggressive war, genocide, violation of laws of war, violation of international humanitarian law during the armed conflict, as well as terrorism, financing of terrorism, attempted assassination of a state official or public figure, and numerous other crimes against Azerbaijan. These all individuals admitted their involvement and the direct participation in the occupation of Azerbaijani lands. As a conclusion, the right to a fair trial before an independent court must be ensured for every individual without any exception, ensuring that fair trial rights are not the end goals. There is a path to sustainable peace, the peace that Azerbaijanis who suffered from the war for more than 30 years wish. Fortunately, Azerbaijan's policy is also directed only for achieving sustainable peace in the region. Understanding the essence and significance of it, I call on all my colleagues to come up with impartial assessment in these cases, and as a representative of civil society, to implement their role and support peace processes between two nations. I thank you.
Thank you. Next one is Ukrainian Legal Advisory Group.
Thank you. Your Excellency, distinguished delegates, my name is Evgenia Kopalkina and I represent Ukrainian Legal Advisory Group. I speak today of the continued unlawful detention by the Russian Federation of 3 Ukrainian OSCE staff members, Dmytro Shabanov, Maxim Petrov and Vadim Golda. These 3 men, Ukrainians, the national staff of the OSCE Special Monitoring Mission in Ukraine. They were detained over 3.5 years ago in the temporarily occupied territories of Donetsk and Lugansk for performing their official duties under the OSCE mandate. Despite their diplomatic protection under OSCE frameworks and international law, they were held incommunicado, subjected to torture, forced into false confession, and sentenced to 13 and 14 years in prison on fabricated charges of high treason and espionage. What makes this case even more alarming is that Dmytro Shabanov and Maxim Petrov were tried under not in existence law of so-called Lugansk People's Republic, and in 2025 their convictions were aligned with Russian law, enabling their transfer to high-security prisons in Russia. This case also exposed a deeper and more uncomfortable truth. National OSCE staff, vital to missions, are uniquely vulnerable in conflict zones. They remain on the ground during escalations and face retaliation from occupying forces as seen in Ukraine. Unlike the swift release of international OSCE staff detained by Russia in eastern Ukraine in 2013 and 2015, Ukrainian staff have now been in Russian captivity for over 3 years, with no clear international strategy for their release. The responsibility is collective. Equally, national staff must receive the same protection and recognition as international personnel, as their safety is crucial of the OSCE success and our collective credibility. Silence is no longer an option if we are not uphold to the founding values of the OSCE. If staff cannot be protected, no OSCE mission can be deemed safe and or legitimate. This concern shared by the current and former staff calls of the immediate and active response. We urge all participant states to make efforts for release of the 3 Ukrainian OSCE staff, a condition for any ceasefire or peace agreement monitoring. Establish a coordination platform involving participant states, the OSCE Secretary General and the families to track and to report on the release progress, keeping families informed. Justice and accountability for the violations committed against the detainees to prevent further breaches of national staff rights and immunities. Lead a public campaign for their release in the diplomatic channels and international forums. Coordinate with Ukraine to ensure that efforts for detainees' release are
prioritized. May I ask you to wrap up, please?
Thank you.
Thank you. Next one is Human Rights Promotion Centered Public Union.
Nazrin Aliyeva, founder and deputy chairman of Human Rights Promotion Center in the Republic of Azerbaijan. Mr. Moderator, dear participants, the independence of the judiciary is the most important aspect of ensuring human rights. Laws can be in the highest form, but if the judiciary is not independent, they can be nothing more. First of all, the courts shouldn't have any dependence on the executive branch. The independence of the Judicial Legal Council as the main body regulating the activities of the courts in Azerbaijan has been ensured. I would like to specifically note that the recent activities of the Judicial Legal Council in Azerbaijan, the decisions taken, the independent assessment of judges, and steps taken to develop the institution of advocacy are already yielding positive results. The rules for selecting judges have been made completely transparent. I believe the Judicial Legal Council in Azerbaijan should be given broad powers in the direction of improving judges. Of course, there is a great confidence that the judicial system will constantly develop by studying world experience in more detail in Azerbaijan. As an NGO representative and young lawyer, I can note that the right to fair trial is ensured both by activities of independent courts and everyone's access to quality legal aid. Article 61 of the Constitution of the Republic of Azerbaijan establishes this principle and recognizes the right of everyone to receive high-quality legal aid. In cases stipulated by law, this assistance is provided free of charge at the expense of the state. In recent years, the significant steps have been taken in Azerbaijan to improve the institution of legal aid at the expense of the state. the establishment of the legal advice centers in the regions, the expansion of free legal aid for low-income population, and the significant increase in the number of lawyers are examples of this. In 2018 and 2022 alone, more than 30,000 low-income persons were provided with legal aid at the expense of the state. And in 2024, more than 5,000 citizens were provided with legal aid at the expense of the state. In addition, the amount of payments for legal aid at the state expense has been gradually increased in the recent years, reaching 11 minutes per working hour in 2025. Although this amount is not entirely satisfactory, the growth trend is considered positive in terms of strengthening the legal aid system. On the other hand, the number of lawyers has increased many times in recent years, currently reaching 2,770 people, and this growth trend continues. In particular, the interest of young people in this profession has increased significantly, and which is an important factor in ensuring the right to fair trial. I believe that the positive impact of free legal aid will expand further, become accessible to all segments of society, and will act as one of the main pillars of ensuring the right to fair trial. I thank you for your attention.
Thank you. Next one is the European Union, please.
Thank you, Mr. Moderator. Albania, Andorra, Bosnia and Herzegovina, Iceland, Liechtenstein, Montenegro, North Macedonia, Norway, Republic of Moldova, and Ukraine have aligned themselves with this statement. Rule of law, including independence of judiciary, the right to a fair trial, and democratic lawmaking are cornerstones of the OSCE's comprehensive security framework. In this regard, we are committed to improving the effectiveness on administration of justice, ensuring fair trials, and transparent processes through an independent and impartial judiciary. It is our collective duty to uphold and defend these fundamental pillars that lie at the heart of the rule of law and that are key to effective oversight in democratic societies. Fair, appropriate, and equitable laws bind all individuals, institutions, and state authorities, safeguarding their integrity and proper functioning. It is our responsibility to promote confidence in the justice system and to ensure that everyone, without discrimination, has the right to a fair trial. Any deviation from these legal principles or arbitrary use of state power stands in clear opposition to OSCE commitments. In the context of Russia's war of aggression against Ukraine, we call for accountability for all international crimes and human rights violations and abuses. OSCE, through ODIHR and Human Dimension Mechanism, can bring its contribution. In this context, we take note with grave concern of the Moscow Mechanism report on the treatment of Ukrainian prisoners of war, including arbitrary killings, torture, and the deprival of the right to a fair trial. Russia's external aggression is accompanied by accelerating internal repression, dismantling the rule of law, and challenging the principles of separation of powers. The continuous harassment of human rights lawyers in Russia is equally concerning, as lawyers have a fundamental role in upholding the rule of law and the human rights of defendants. We call on Russia to end its political misuse of the judiciary and the law enforcement, recalling the importance of the independence of judiciary and the right to a fair trial. The EU remains deeply concerned about the human rights situation in Belarus. While we welcome the recent release of political prisoners in Belarus with the engagement of our American partners, there are still at least 1,198 political prisoners unjustly detained. We reiterate our calls for the immediate and unconditional release of all remaining political prisoners in Belarus and for their effective rehabilitation. The EU affirms that safeguarding judicial independence, ensuring the right to a fair trial, and upholding democratic lawmaking are indispensable to peace and stability in the OSCE region. We stand ready to work with our partners to uphold these values and ensure justice, accountability, and trust in democratic institutions. I thank you.
Thank you. That was, wow, exactly 3 minutes. Excellent. Next one is Azerbaijan Institute for Democracy and Human Rights. Ladies and gentlemen, I was just reminded to remind you, please, when civil society is speaking, speak from the civil society desk. So, next one is Azerbaijan Institute for Democracy and Human Rights.
Thank you, Mr. Chair. Excellencies, ladies and gentlemen, my name is Ahmad Shahidov. I represent Azerbaijan Institute for Democracy and Human Rights. And we live in a world where international law is tested every single day. In Ukraine, Russian missiles strike civilian homes, kindergartens, and hospitals, acts the international community rightly defines as the war crimes. The civilized world demands accountability because there can be no peace without justice. But the same principle must apply everywhere, not only when it's politically convenient. If war crimes are punished in Europe, they must also be punished elsewhere. Justice cannot have borders. Over the past 4 days of this conference, I have listened to several of my Armenian colleagues, Armenian representatives, and especially the members of the Armenian National Committee of America, ANCA, who have tried to portray the ongoing trials in Baku as a political persecution. Let me be very clear. This is not politics. This is justice. The individuals on trial in Baku today, especially Arayik Harutyunyan, Arkady Gugasyan, Bako Saakyan, David Ishkhanyan, David Babayan, Levon Natsakanyan, and others are not activists, not journalists, and not political prisoners. They are accused concrete war criminals responsible for acts of terrorism, mass killings, torture, and attacks on civilians during Armenia's decades-long military aggression against Azerbaijan. And let me remind you, during the 2020 war, Armenian forces deliberately targeted peaceful Azerbaijani cities, Ganja, Barda, and Tartar. Hundreds of civilians, including women and children, were killed by cluster munitions. These attacks were not accidents, they were crimes. Today, those responsible are facing trial openly, transparently, and under the rule of law. The hearings at the Baku military court are public, attended by defendants' lawyers, translators, victims' families, and journalists. Each accused person enjoys full legal defense and the right to a fair trial in full compliance with international standards, including the Geneva Conventions and the principles of due process. Let us be honest. When the world demands accountability for Russian generals who bombed Mariupol, we call it justice. When Armenian commanders face justice for bombing Ganja, we must call it the same, justice. Selective law is not justice, it's politics. I also want to remind this room that on August 8, 2025, this year, I was in Washington, D.C. at the White House when the Azerbaijan-Armenia peace agreement was signed under the mediation of President Donald Trump. And that day, the same organization, ANCA, Armenian National Committee of America, issued a statement condemning the peace process and calling it a betrayal. Today, the same organization is here in Warsaw, opposing justice and defending those war criminals. This is not human rights advocacy. This is political propaganda. And Azerbaijan does not seek revenge. It seeks accountability.
May I ask you to
and
wrap
our
up,
courts
please?
are not punishing nationality. They are punishing crime. Thank you for your attention.
Thank you. Next one is Democratic Choice of Kazakhstan.
Здравствуйте, благодарю.
Good morning. Thank you for this opportunity. I'm a coordinator of the staff of Democratic Choice for Kazakhstan. I want to draw your attention to systematic violation of the right to a fair trial in Kazakhstan. For the past years, the Nazarbayev-Tokayev regime made this practice of closed court proceedings, and these proceedings normally don't let in any media or civil society representatives. The court room only has a lawyer and a defendant, a claimant. And this violates one of the basic fundamental rights of the person to a fair trial. As a result, the human rights defenders, advocates, and bloggers have long sentences for a long term for the materials they write about the people in power. In August 2024, the civil activist Aslanbek Jayburatov was sentenced to 7 years in custody based on the closed proceeding under the closed doors, and the accusations were based only on his forced confessions. Another human rights defender got sentenced to 5 years in custody for distribution of drugs. Although his proceedings was accelerated, it lasted only 2 weeks, and all the evidence was denied by court. The basis for his charges were the testimony of an anonymous witness. Both those examples show the lack of independence by the Kazakhstan courts. The judicial system in Kazakhstan is basically a tool of the regime for repressions. Other activists were sentenced for public criticism over the war started by Russia and Ukraine. Another female activist was sentenced for the criticism over the regime. Normally, at such proceedings, there are no evidence and any arguments are disregarded. That is how Kazakhstan violates blatantly its international commitments and denies any monitoring processes. We call for the OSCE participants to ask Kazakhstan to stop this practice of closed court proceedings, and we also call for the parliaments of Canada, US, and the EU asking for more active monitoring of such politically motivated proceedings. Thank you for your attention.
Thank you. Next one is Catalan National Assembly.
Thank you, Mr. Moderator. My name is Ariadna Heinz, and I speak on behalf of the Catalan National Assembly, a grassroots organization defending the right to self-determination of the Catalan people. Today, I will address key challenges to the rule of law in Spain, especially within the judiciary. Spain's judiciary has long been criticized by international bodies for politicization and lack of impartiality. Reports by the United Nations Human Rights Committee, the Council of Europe Commissioner for Human Rights, and international NGOs have all denounced a judiciary that is systematically used as a tool to silence political dissent. One clear example is the ongoing political persecution of Catalan pro-independence leaders and activists. Since the 2017 peaceful referendum on independence, 4,000 Catalans, including teachers, mayors, and activists, have faced judicial harassment, disproportionate charges, and even accusations of terrorism for their activism. The 2024 amnesty law, approved to redress injustices, has been obstructed by Spanish judges who refuse to apply it to peaceful Catalan politicians and activists, and instead use it selectively in favor of police officers accused of disproportionate violence, while the very victims of that violence remain without justice. This is a clear violation of the principle of equality before the law. In 2022, the United Nations Human Rights Committee ruled that Spain violated the political participation rights of Catalan parliamentarians. In 2023, the United Nations Special Rapporteurs condemned abuses linked to the Catalan Gate spyware scandal, where over 65 Catalan leaders, lawyers, journalists were illegally targeted. They highlighted how espionage, infiltration, and lack of remedies violate privacy and fair trial rights. Yet Spain has failed to implement these rulings and recommendations so far. These breaches of the rule of law sabotage democratic participation, freedom of expression, and the right to self-determination. The erosion of the rule of law in Spain undermines not only Catalonia's rights, but also the credibility of the overall European democratic framework. The time has come to end judicial repression and let democracy prevail. We thus call on the OSCE participating states to urge Spain to fully implement the human rights rulings of international bodies, guarantee fair trial rights, ending the misuse of anti-terrorism laws against peaceful activists, and apply the 2024 amnesty law impartially. Thank you for your attention.
Thank you. Next one is Ukraine.
Thank you, Ambassador. Distinguished participants, according to the ODIHR Ukraine Monitoring Initiative and the United Nations Human Rights Monitoring Mission in Ukraine, Russia continues to apply its own criminal legislation to temporarily occupied Ukrainian territories in violation of international humanitarian law. The missions have documented the systematic deprivation of liberty, torture, denial of access to counsel, and unlawful transfer of detainees to the territory of the Russian Federation. Independent experts confirm that Russia's action constitute deliberate dismantling of judicial guarantees and the weaponization of courts as tools of repression. Findings presented in 2025 report, Denial of the Right to Fair Trial as an International Crime during Russia's war against Ukraine by leading Ukrainian human rights organizations, expose a coordinated state policy of judicial prosecution. Over 1,800 Ukrainian civilians and more than 6,000 prisoners of war have been subjected to criminal prosecution in Russian-controlled courts. The so-called trials are characterized by the absence of defense, coerced confessions extracted under torture, secret proceedings, and retroactive application of Russian criminal law in direct violation of the principle nullum crimen sine lege. Russia's constitutional and Supreme Courts institutionalized denial of the existence of an international armed conflict and authorized the integration of the occupied territories into Russia's judicial system. This has enabled a full-scale legislation of repression where courts convict civilians and prisoners of war for acts committed before occupation or for exercising rights protected by under the international law. Independent sources concur that these practices amount to war crimes and crimes against humanity, in particular the war crime of denial of a fair trial and persecution on political and national grounds. Ukraine's message is clear. Even in wartime, we remain committed to the rule of law, reforming judicial governance, preserving the independence of anti-corruption courts, and aligning national legislation with the Venice Commission's advice and the EU acquis. We urge participating states and the OSCE institutions to refrain from recognizing any judicial or legislative acts of the occupation authorities, ensure accountability through universal jurisdiction and international criminal justice mechanism, including the ICC, support independent monitoring, including ODIHR and HRMMU documentation efforts to ensure that every recorded violation becomes admissible evidence for the future prosecutions, and assist Ukraine's judiciary in its ongoing reforms and resilience building amid the war. I thank you, Mr. Chairperson.
Thank you. Next one is the Union of Informed Citizens.
Thank you, Mr. Moderator. My name is Daniel Ioannisyan. First of all, I would like to speak about independence and efficiency of judicial system in Armenia. Unfortunately, we observe political motivated investigations where actually a criminal offense is committed by a person, but there are clear signs of some parts of investigation and punishment are politically motivated. We also observe a very serious problem with the efficiency of the judicial system in our country. Both criminal investigations and administrative or civil court hearings are sometimes taking too long. Sometimes courts are judging not based on rights and justice, but based on procedures. As a result of those problems, the efficiency and trust towards the system are very low. That's leading to a number of problems, starting from mistrust towards state up to attempts by people to find justice by other means. That could be through criminal subculture, organized crime groups, or even vendetta. But ladies and gentlemen, at the same time, I would like to talk about so-called criminal investigations against Armenian prisoners of war and captive civilians in Azerbaijan. We all know that the independence of the judiciary in Azerbaijan is extremely low, and that applies not only to Armenian POWs and captives, but also to millions of Azerbaijanis. But you wouldn't see Azerbaijanis NGOs talking about that. They are not instructed to do so, and they will face the whole beauty of political prosecution in their country if they will criticize their country. But back to Armenians who are being prosecuted for things they've never done. Some are charged with war crimes, while they're simply civilians lost in the contact line and caught by Azerbaijani troops. People like Gevorg Sujan, Vigen Euljan, Rashid Beglaryan, David Davtyan, Ruben Vartanyan, David Babayan, and many others have never attended any combat, never attended or led any military group. So how could they commit war crimes? They're not POWs, they're not criminals, they're simply people caught by Azerbaijan and used as a tool of leverage on Armenia. Instead of talking about absence of independent judiciary in their country, Azerbaijani NGOs are speaking about number of war-related incidents. Yes, what happened in Ganja during the war is terrible, but it is clear that it's a terrible accident where target was a military airport located next to a civilian building that was hit. And again, that's a very terrible case. They're speaking of cluster munitions. I will ask them to speak about cluster munitions that their military used against civilian populated parts of Stepanakert, Hadrut, and other cities that were recorded by trusted international organizations. Thanks a lot.
Thank you. Next one is solidarity with others.
Good morning. Coşkun Yorulmaz on behalf of Solidarity with Others, based in Brussels. Over 2 years ago, in September 2023, the Grand Chamber of the European Court of Human Rights, in one of its most pivotal judgments, ruled that Yüksel Yalçınkaya, a teacher convicted in Turkey of being a member of the Gulen movement, had in fact never received a fair trial and was arbitrarily convicted. The evidence against him consisted of using a then publicly available mobile messaging application, being a member of a particular teachers' union, and using the services of a specific Turkish bank. The judgment is particularly significant as almost 2 million Turkish citizens have been investigated on the same grounds and hundreds of thousands have been imprisoned. The court instructed Turkey to reopen the criminal proceedings for the applicant. It also directed Turkey to address the systematic failings within its judicial system. Following the decision, the president of Turkey stated that the country would not comply with the ruling. Unsurprisingly, the criminal court, which reopened the applicant's case, determined that there was absolutely nothing wrong with its initial verdict. Thousands of applications that the European Court of Human Rights has communicated to Turkey, requesting immediate retrials of breaches of the right of the fair trial and the principle of no punishment without law, are still awaiting resolution. In the meantime, Turkish citizens continue to be arrested and imprisoned on the same grounds. Ensuring that Turkey implements this judgment is vital for literally millions of people who have been unjustly investigated, prosecuted, convicted, and imprisoned. Turkey must begin to take its international obligations more seriously. For this reason, Turkey should immediately stop the prosecution of alleged members of the Gulen movement under its anti-terror legislation, as well as criminalizing lawful conduct, such as using messaging application. Turkey should revise its unlawfully broad and ambiguous anti-terror legislation in line with the findings of the European Court of Human Rights in its Demirtas and Yalçınkaya rulings. Turkey must also adopt general measures to ensure retrials for its citizens who have been unlawfully convicted following unfair proceedings, regardless of whether their convictions have been upheld by appellate courts. Finally, we call upon the OSCE and individual member states to remind Turkey of its international obligations concerning the protection of the rule of law. I thank you.
Thank you. Next one is the Public Foundation Al-Ruh Haq.
My name is Bakhijat Teragozhina. I'm from Kazakhstan. The independence of the judicial system is a vital condition for the existence of any free society. A judge who is afraid to make decisions against the will of the authorities cannot ensure justice. And without justice, there is no trust, no security, and no progress. Today, I would like to draw attention to a trend where freedom of speech is being undermined through an independent judicial system. I'm referring here to the case of 16 journalists from Radio Azatik, whose accreditation was denied by the Kazakh Ministry of Foreign Affairs in 2025. This decision effectively paralyzed the work of one of the few independent media outlets in Kazakhstan. Without accreditation, journalists cannot ask questions of government officials, attend official events, or gather reliable information. Azatik editorial office presented convincing evidence. All applications were submitted in advance and there were no violation of the law. However, the court refused to protect journalists and their right to practice their profession. This decision was not just a legal formality. It showed that in Kazakhstan, the court is not an arbiter between the authorities and journalists, but has become an instrument of control. And here is the key relationship becomes apparent. Where there is no independent court, there can be no freedom of speech. Because journalists who face censorship, arbitrariness, and threats must have a place where their rights will be protected. Where there is no such place, when judges are forced to act under pressure, every journalist understands that they will be left without protection for telling the truth. And then silence, dissent, self-censorship, fear. In case of Radio Azatik, we also see Akorda's clear political interest against the backdrop of President Tokayev's upcoming official visit to Washington. Where there is no opportunity to influence, when your arguments are ignored, it becomes especially sad that journalists and their work become bargaining chip in these negotiations. Unfortunately, this is exactly how authoritarian systems work. Through blackmail. We ask the OSCE to call on Kazakhstan to ensure the real independence of the judiciary as a key condition for protection of freedom of speech and human rights. Second, demand a review of the decision related to refusal to accredit Radio Azatik journalists and restore their right to practice their profession. Thank you very much.
Is Human Rights Center Zmina. Human Rights Center Zmina. Nobody here. Then I will proceed in the list with the organization Protection of Rights Without Borders.
Thank you, Mr. Moderator, dear guests, participants, delegates. My name is Hasmi Karutyunyan from the local NGO Protection of Rights Without Borders from Armenia. Judicial independence in Armenia remains problematic. While there are all the legislative grounds formally guaranteeing the independence of judiciary, both at individual and at institutional level, its practical implementation, however, remains inconsistent. The resignation of the Supreme Judicial Council's chairperson through private phone message from a prime minister underlines the need to reinforce the independence of judiciary and Supreme Judicial Council's independent status while ensuring its full autonomy. The system of selection and promotion of judges sometimes lacks merit-based approach and is often influenced by political considerations. There are concerns with disciplinary proceedings against judges as well. Our monitoring has revealed that in certain cases, the objectiveness of disciplinary proceedings against judges is compromised. There is no uniform practice on adjudication and reasoning of cases on disciplinary liability and sanctions of judges. Additionally, the pretrial detention is increasingly being used as a tool to punish political opponents and silence dissenting voices, raising serious concerns about the misuse of the justice system for political needs. Distinguished delegates, participants, when we talk about independence of judiciary and fair trial standards, we can't forget Azerbaijan, as the legal proceedings brought against Armenian prisoners of war raise serious concerns. These trials have consistently failed to meet international fair trial standards. They are marked by procedural flaws, an automatic presumption of guilt, the absence of witness testimony, ineffective legal representation, and lack of impartial and independent tribunals. Judiciary in Azerbaijan is corrupt and subservient to executive. This is not just our opinion, but fact established by different international organizations and bodies. The UN CAT, for example, in its concluding observations, repeatedly stressed that the public lawyers in Azerbaijan are not independent, and the bar in Azerbaijan is dependent on the executive. Taking into consideration the presented, we call international organizations present here to continue to prioritize and strictly monitor the judicial reforms in Armenia, as well as to exert meaningful pressure on Azerbaijan to release all the illegally detained Armenians in Baku. Thank you.
Thank you. Next one is Armenia.
Thank you. Mr. Moderator, ladies and gentlemen, an efficient, impartial, and independent judiciary is the backbone of any functioning system of democratic checks and balances. The role of the judiciary in contemporary public life has changed over the centuries. Sadly, judges are no longer just the mouthpiece of the law, as described by Montesquieu. When the judiciary lacks independence and judges are subject to pressure from the executive branch, the impartiality of their rulings is compromised. Such circumstances fundamentally weaken the guarantees of the right to a fair trial, which is essential for the rule of law. Mr. Moderator, each participating state of the OSCE is obliged to implement appropriate measures to guarantee the independence of the judiciary and to ensure that all individuals enjoy the right to a fair trial in line with their international legal obligations and the OSCE Copenhagen document of 1990. Dear colleagues, in recent years, Armenia achieved tangible progress in this regard. As part of our ongoing efforts to advance legal and judicial reforms, Armenia adopted the Strategy for Judicial and Legal Reforms 2022-2026, together with its action plan, which consists of 12 strategic objectives. These reforms are focused on reinforcing judicial independence, increasing efficiency, and promoting integrity, all anchored in the principles of transparency and accountability. In October 2023, Armenia adopted a new judicial code, which created clearer and more transparent mechanisms for reviewing and appealing disciplinary decisions concerning judges, thereby strengthening both accountability and independence. In addition, the establishment of the Appellate Anti-Corruption Court represents a decisive step in addressing corruption through specialized judicial expertise. Mr. Moderator, Armenia remains firmly committed to deepening these reforms. We believe that by strengthening judicial independence and enhancing public trust in the judiciary, we are laying the foundations for a resilient democracy and a stronger rule of law. In this spirit, Armenia stands ready to continue cooperation with international partners and institutions to share experiences and best practices and to contribute to our common goal of building fair, transparent, and accountable judicial systems. I thank you.
Thank you. Next one is Payom TV.
Есть ли у нас представитель? Dear moderator, dear representatives of the participating states, dear colleagues, my name is Shavkatjon Sharipov. I represent the informational and analytical platform Payom TV. Dear colleagues, we cannot talk about democracy if the judiciary is not independent. When judges do not provide justice, democracy becomes something fake. In Tajikistan, judiciary is reporting to the state authorities. In political cases, the decisions are taken in advance. Those who implement, who are to protect law, they become victims. Lawyers Buzurg Mer Yorov and Nuruddin Makhamov were convicted only for implementing their profession. They protected political prisoners and demanded for justice. The laws are taken in publicly without public discussions. For stability justifies violations. Over 30 years of arbitrariness breached trust, and that is why I appeal to the participating countries of OSCE to process, to assess the activity of the regime of Emomali Rahmon in the International Criminal Court in The Hague. Only legal assessment could be a good way to the rule of law. The rule of law is not the question of one country. It is security, trust, and responsibility of the international society. Thank you very much.
Next one is the Public Foundation National Endowment for Prosperity.
Thank you. I am Shaykhmetova, expert of Public Foundation National Democracy for Prosperity, judge. 2024, the constitutional law of the Republic of Kazakhstan in new cassation courts was created. The cassation instance was performed by the Supreme Court of the Republic of Kazakhstan, in which cassation proceedings were carried out by the collegiums in civil, administrative, and criminal cases. In accordance with the decree of the President of the Republic of Kazakhstan, Tokayev, from July 2025 began to function cassation courts. An important innovation was the introduction in the extensions cassation mechanism in civil and criminal proceedings. This means that now all cassation complaints are subject to mandatory consideration on the merits without preliminary section. Since 2021, administrative justice has been operating in Kazakhstan 4 years. Administrative courts have been working to consider public law disputes, the one on the parties and state body, and the other on simple citizens. Administrative courts consider these claims and the principle of the burden of proving the defendant. In addition, in Kazakhstan, some resonance cases are carried out without direct broadcast, with the participation of the media. According to statistic, 58 decisions of the made in favor of citizens. И хотела бы сейчас сказать.
So now I would say that there's been some criticism over Kazakhstan about some proceedings behind the closed doors, but this is not true. According to the Kazakhstan law on state secrecy, the proceedings are implemented behind closed doors if they refer to the commercial secrecy, the interest of underage, the sexual crimes, and the state secrecy. Besides, for the past years, there's been an increase of online proceedings, which means that any citizen can watch those proceedings, including mass media. That's why the results of the judicial reform now show that there's been the preconditions for the transparent justice and for wider access for citizens to the judicial processes.
Thank you very much. The next speaker is Crimean Tatar Resource Center. Do we have the Crimean Tatar Resource Center? Then I will move on to the next speaker on the list is Bnai Brit International. Do we have Bnai Brit International in the room? No. Then the next speaker is IC Law Armenia.
Thank you, dear moderator. I'm Siranur Sahakyan, Director of International and Comparative Law Center. I address you today in a dual capacity, as a human rights defender and civil society representative committed to the rule of law, and as a counsel representing hundreds of Armenian victims of war crimes before regional and universal mechanisms. Victims consistently denied justice in Azerbaijan. The judiciary in Azerbaijan has been weaponized as an instrument of state repression. The clearest evidence lies in the judgments of the European Court of Human Rights, which addresses abuses of state power pursued with ulterior political motives. This provision is invoked only in the rarest circumstances and against a small number of states. Yet, strikingly, 1/3 of such judgments concern Azerbaijan. This record demonstrates that political interference in its judiciary is not incidental but systemic, an irreparable collapse in which court serves not justice but repression. Through hostage diplomacy and discriminatory practices, Azerbaijan organizes sham trials of Armenian prisoners. Armenians are targeted not for their actions, but solely for their identity. They are denied access to independent lawyers. Court proceedings stripped of independence and impartiality became state rituals of humiliation. Meanwhile, the government offers assurances before this forum that Armenian prisoners enjoy all rights, including access to lawyers. Yet I can attest that, as their appointed counsel, with authority recognized by the European Court of Human Rights, I have been denied every request to meet them. For 5 years, the number of permitted meetings stands 0. If this is what protection of rights looks like, we may well imagine the reality of all other fair trial rights in Azerbaijan. Instead of providing remedies, Azerbaijan attempts to shield behind the National Ombudsman, a body downgraded to B status precisely because it fails to meet the independence requirements of Paris principles. Far from functioning as a safeguard, it operates as a facade, designated to deflect international scrutiny while torture and ill treatment of Armenian prisoners continue unchecked. Civil society organizations operating in Azerbaijan, which should defend the rule of law, remain silent in the face of torture, killings, forced disappearances, and even the decapitation of Armenian civilians. The same actors who acknowledge the lack of judicial independence in Azerbaijan choose to deny it in Armenian cases, overlooking the reality of discrimination and ethnic hatred that makes justice unattainable. And where are these same voices now, as Armenians are subjected to sham trials and tortures? Their silence then and their silence now is not the conduct of human rights actors, it is complicity of state crimes. I thank you.
Thank you. Next one is Media Initiative for Human Rights.
Thank you.
My name is Anna Zavako, and I speak today on behalf of the Media Initiative for Human Rights, Ukrainian NGO that for years has documented Russia's unlawful detention and trials against Ukrainians, both civilians and prisoners of war. Since 2014, we have been documenting the quasi-legal judicial system operating in the occupied territories of Ukraine, which has now become integrated into Russian judicial system. The European Court of Human Rights has repeatedly found that Russia exercised effective control over parts of Ukraine from 2013. And the court has treated Russia as legally responsible for the authorities, measures, and systems, including the application of law and courts operating in those territories. Together with Human Rights Center's MINA, we analyzed hundreds of court proceedings and conducted research on Russia's policy of judicial persecution of Ukrainian civilian detainees and POWs. The report concludes that these trials demonstrate clear signs of war crimes, specifically the denial of the right to a fair trial, and in case of civilians, persecution as crime against humanity. The report also shows a 300% increase in sentences against Ukrainian defenders since February 2022. Hundreds of Ukrainian prisoners of war are being labeled as terrorists. More than 400 of them already were sentenced in Russia. These trials are politically motivated, discriminatory, and serve one purpose: to portray Ukrainian defenders as criminals and to justify Russian aggression. These sham trials are based on forced confessions under torture and fabricated evidence, while hearings happen behind closed doors and state-appointed lawyers can simply play phone games during hearings. Our report was mentioned in Moscow mechanism as key evidence showing that Russia uses the judicial system to repress Ukrainian POWs and civilians. The Moscow mechanism clearly states these practices are systematic, they deprive prisoners of their rights under the Geneva Conventions, and may amount to war crimes. We urge OSCE states to ensure that Moscow mechanism recommendations are taken into account. Monitoring the implementation is crucial, as justice cannot stop at reporting. It must lead to accountability. Also, it is essential to expose the criminal intentions of Russian Federation and to invalidate the decision of Russian courts against Ukrainian prisoners of war and civilians. Courts that Russia presents as to world as legitimate are fabricating hundreds of cases. Finally, I invite you to join us today at 2:30 in the Krolevsky Room for the side event denying a fair trial as an atrocity crime during Russia's war against Ukraine. Together with our partners, we will shed more light on this widespread practice. Thank you.
Thank you. Next one is Armenian National Committee of America, Western Region.
Distinguished delegates, honorable moderator. My name is Garen Jimbashan with the Armenian National Committee of America. A few moments ago, a representative from Azerbaijani civil society claimed that the 23 Armenian political and community leaders unlawfully imprisoned in Baku are, quote, war criminals and obstacles to peace. Such statements are not reflections of civil society. They are echoes of state propaganda. It is evident that their imprisonment serves a political purpose to erase a leadership that once represented the will of the indigenous Armenian people of Artsakh. To call these captives a threat to peace is to invert reality itself. They are not the ones undermining peace. They are victims of its absence. Peace cannot be advanced by silencing those who once governed through ballots, not bullets. The Amnesty International statement of September 2023 makes this clear. Azerbaijan's criminal justice systems has been systematically weaponized to stifle dissent and fabricate charges under the guise of counterterrorism. Torture, arbitrary detention, and the denial of fair trial guarantees are documented not as allegations, but as patterns. Detainees are denied access to independent counsel and tried in secrecy. Trials are closed to the public, shielded from international observers, and conducted under the shadow of judiciary that answers not to the law, but the direct control of executive power, the one man himself, Ilham Aliyev. This is not the rule of law, rather the abuse of it. These proceedings violate every principle enshrined in the International Covenant of Civil and Political Rights, the Geneva Conventions, and the Helsinki Final Act. When elected representatives are prosecuted for fulfilling their democratic mandate, justice is no longer a means of peace. It becomes a weapon of punishment. And so, calls for rule of law from Baku ring hollow when the law itself has been reduced to an instrument of fear. Therefore, we call upon this body and its participating states to insist on independent international observation of all judicial proceedings involving Armenian prisoners. establish permanent mechanisms to monitor Azerbaijan's compliance with the Convention Against Torture and OSCE commitments by activating the Moscow mechanism. Because the rule of law cannot exist where verdicts are scripted before trials begin, nor with impunity for torture. And it cannot survive when entire populations, the displaced Armenians of Artsakh, are denied even the basic right to seek justice and the right of return. If this conference is to mean anything, it must make clear that peace cannot be built on prosecution and justice cannot be selective. It brings me great honor to see that people are listening to my speeches, but I must remind them that their listening does not have to be as selective as their judicial systems in their countries. True stability is not achieved through silencing the victims, but through holding the perpetrators to account. Thank you for your attention.
Thank you. Next one is Stichting Mensenrechten zonder Grenzen.
My name is Hans Noot. The Association Human Rights Without Frontiers Netherlands is deeply concerned about the increasing number of fabricated trials in Russia against dissidents, pacifists and peaceful non-Orthodox people who are sentenced to very heavy prison terms. In September, on the basis of the latest research work of the Russian Civic Association OVD Info, we have identified 33 cases of Russian citizens sentenced for alleged political reasons to prison terms from 8 months to 15 years, total almost 180 years. In August this year, in 21 cases, Russian citizens were sentenced for so-called political reasons to effective prison terms from 1 to 18 years, in total 150 years. These statistics do not claim to be exhaustive, but only reflect a part of the reality. The charges distorted and misused by the judiciary so far to fit into the criminal code are, for example, first, dissemination of knowingly false information about the Russian army motivated by political and national hatred. In August, a resident of Bakhana was sentenced to 18 years in prison for the case of anti-war posts. Second, financing of extremist activities. In September, Moscow activist Konstantin Kotov was sentenced in absentia to 5 years in prison because of donations for the Anti-Corruption Foundation. Third, planning activities of a terrorist organization and participation in these activities. Last month, in Saransk, a district court sentenced 2 Jehovah's Witnesses, Mikhail Shevchuk and Alexander Neverov, to over 6 years in prison for organizing peaceful religious activities in private homes. Victor Urso, a 16-year-old Jehovah's Witness, was also sentenced to 6 years in prison into a penal colony for organizing prayer meetings in his own home. Fourth, public incitement to terrorist activities and justification of terrorism. In September, a volunteer who helped Ukrainian refugees in Kursk region was sentenced to 5 years in prison. More fabricated charges like incitement to hatred or enmity.
May I ask you to wrap up, please?
One more sentence. Lawyers defending prosecuted members of civil society in Russia are indeed of the highest protection and support because they are under constant threat of being arrested. Thank you.
Thank you. Next one is the Forum of Tajik Free Thinkers. Forum of Tajik Free Thinkers. Yes.
Да, господин модератор, я здесь.
Yes, Mr. Moderator, I'm here. My name is Salim Sultanzada. I represent the Forum of Tajik Free Thinkers. Ladies and gentlemen, dear representatives of member states, dear human rights defenders, I would like to pay your attention today to one of the key problems in the sphere of human rights is the lack of independence of judiciary and the systematic lack of access to just court. The courts are, in fact, under full control of the executive authorities, especially president and secret services. Judges are appointed and dismissed by the president. This make them dependent. Any attempt of disagreeing with the president will lead to the repression against them. Their life, health, and well-being is under threat. Judges know if the decision is not at par with the president orders, they can be dismissed. They can be recommended to leave their duty. This impedes them from taking decision based on the law and their conscience. Political cases, criminal cases, and opposition members are being preceded by courts just formally without access of lawyers, legal assistance. All the verdicts are being approved by the president and other authorities in advance. The state must provide every citizen an open and independent court, but instead the state created the atmosphere of control and fear. In order to make any kind of justice in Tajikistan, we recommend to appoint an independent court judge council, which will select and appoint judges. There is a need to provide protection for lawyers, restore public control over the judiciary. And to wrap up, I would like to say, without just judiciary, independent judiciary, there cannot be democracy. We appeal to the international organization and OSCE to pay special attention to protect judges, lawyers, and human rights defenders in Tajikistan.
Crude accountability.
Thank you very much. Mr. Moderator, dear colleagues, my name is Kate Waters. I'm the Executive Director of Crude Accountability. I'm here to speak about two cases in Azerbaijan which are emblematic of the broader problem in the country of denial of access to a fair trial, observation of and respect for the rule of law, and democratic lawmaking. Our colleague, Dr. Gubadi Badoglu, an economist and anti-corruption activist, has been detained since July 2023, when he was brutally arrested and held at first in pre-trial detention and since April 2024 under house arrest. His trial has been frozen and he has been denied access to much-needed medical treatment, the right to travel, and resolution of the trumped-up charges against him. The failure of the government of Azerbaijan to provide him with the fair trial to which he is entitled has landed him in a legal gray zone in which his rights are essentially placed on hold. Dr. Ibadoglu's brother, Galib Bayramov, an independent journalist and civil society activist, has also been targeted by the Azerbaijani authorities. Mr. Bayramov has dedicated his professional life to independent policy analysis, human rights advocacy, and the exposure of systemic corruption. He has also exposed cases of political persecution, defended political prisoners, including his brother, and filed petitions challenging the unlawful practices of state authorities. As a direct consequence of these activities, he is now subjected to politically motivated prosecution. In March, he was summoned to the Grave Crimes Investigation Department in connection with a fabricated case targeting civil society activists and NGOs. In April, he was formally charged and placed under continuous police surveillance, and since then he has been repeatedly interrogated under coercive conditions and subjected to persistent intimidation. On the 5th of September, the pretrial investigation against him was declared complete. His case was referred to the Baku Court on Grave Crimes, and the first hearing was held on the 8th of October. He has been formally indicted with alleged legalization of property attained through crime and alleged abuse of power. The next court hearing is planned for October 22nd, when the court will present its evidence against him. These charges are wholly unsubstantiated and carry a potential prison term of 8 to 12 years. He's being prosecuted solely in retaliation for defending his brother. His only crime is being Dr. Gubadze Badoglu and standing up for justice. The prosecution is clearly intended to silence him permanently, criminalize his legitimate civil society activities, and punish him for exercising his fundamental rights to freedom of expression and association. The case is consistent with Azerbaijan's well-documented pattern of politically motivated prosecution against civil society activists, journalists, and human rights defenders. We demand the immediate and unconditional release of Dr. Ibadoglu, Mr. Bayramov, and all of Azerbaijan's political prisoners. Thank you.
Thank you very much. Also you, down to 3 minutes exactly. Very good. Next one is Public Union for Gender Equality and Women Initiatives.
Thank you, Mr. Moderator. Nigar Ramazanova, Public Union for Gender Equality and Women Initiatives. Dear participants, for almost 30 years, Armenia carried out military aggression against Azerbaijan and occupied around 1/5 of our internationally recognized territory. During this long occupation, tens of thousands of Azerbaijanis were killed, and hundreds of cities, towns, and villages were completely destroyed. All the occupied areas were ethically cleansed of their Azerbaijani population. At the same time, about 300,000 Azerbaijanis were forcibly expelled from Armenia, where they had lived peacefully for centuries. These people lost their homes, communities, and cultural heritage. The occupation and mass displacement clearly violated international humanitarian and human rights law. During those years, Azerbaijani prisoners of war and civilian hostages were also subjected to torture and inhuman treatment by Armenian armed forces. Nearly 4,000 Azerbaijanis are still missing, and their families continue to suffer without knowing the fate of their loved ones. After the end of the conflict in 2020, Azerbaijan took a responsible and humane approach. All Armenian prisoners of war were repatriated in full accordance with the Geneva Convention. Azerbaijan also returned the bodies of more than 1,700 Armenian servicemen to Armenia. However, the few Armenian citizens who remain in custody in Azerbaijan are not prisoners of war. They are accused of committing serious crimes, including war crimes, crimes against humanity. Their trials are conducted transparently, in accordance with Azerbaijan law and international legal standards. Therefore, the allegations made by some Armenian organizations are completely baseless. The judicial process in Azerbaijan is open to the public and follows due legal procedure. The independence of courts should be respected, and interfering in lawful trials of those responsible for serious violation should be avoided. Azerbaijan believes in justice, peace, and accountability. Only by recognizing the truth and ensuring justice for all victims can be built a stable and peaceful future for our region. Thank you.
Thank you. Next one is European Armenian Federation for Justice and Democracy.
Aram Kevorkian from the European Armenian Federation for Justice and Democracy. Thank you. Distinguished Chair, esteemed colleagues, we are gathered here today to reaffirm the foundational democratic principles of rule of law and an independent judiciary. As the European Armenian Federation for Justice and Democracy, we must draw the attention of this plenary session to a profound systematic failure of these principles by an OSCE participating state, Azerbaijan. The Azerbaijani judiciary operates without the impartiality required for a fair trial and serves as a tool of executive power. This lack of independence is more glaringly evident in the cases of Armenian prisoners of war and civilian hostages who continue to be unlawfully detained in Baku. International reports, including appeals made to the European Court of Human Rights, confirm that these individuals have been subjected to cruel and degrading treatment, psychological torture, and a flagrant denial of due process. Their categorization as saboteurs or terrorists, a cynical legal maneuver to bypass the protections of the Geneva Conventions, is nothing more than a pretext for holding political prisoners. Azerbaijan has officially acknowledged the detention of Rupen Vartanyan, David Ishkhanyan, Viken Uljekian, and 20 other Armenian hostages who are routinely denied access to their lawyers and are subjected to manipulative court proceedings. Despite this, independent investigations report the possibility of up to 80 Armenians held captive in Baku, whose fate is fully unknown. The subsequent judicial proceedings are not trials. They are predetermined political spectacles designed to normalize and legitimize war crimes. Despite what its representatives claim in this room, Azerbaijan also routinely disregards rulings and decisions of the ECHR, something its officials publicly and brazenly declare as a point of pride. This weaponization of the justice system is not reserved solely for these cases. We must also note that the same politically controlled judicial apparatus is routinely deployed to silence domestic dissent. Journalists, human rights defenders, independent media figures, and civil society activists are consistently subjected to fabricated criminal charges, leading to their arbitrary arrest and prolonged detention, according to multiple reports by OSCE-CRP, Amnesty International, and multiple bodies. These are not opinions, these are fact-checked reports. These retaliatory prosecutions highlight that the absence of judicial independence in Azerbaijan is a systematic tool of repression. According to Caucasian Note and Union for the Liberty of Political Prisoners of Azerbaijan, as of 2024, the number of these political prisoners has reached 392. When the courts are weaponized to facilitate torture and rubber-stamped arbitrary detentions, the entire fabric of the rule of law collapses. Do not allow commitments to judicial independence to be reduced to mere rhetoric. The fate of the Armenian hostages is a test for the OSCE's credibility to the values and principles that bind its participating states together. We must act now. We need accountability. Thank you.
Thank you. I now invite Institute for Reporters' Freedom and Safety.
Thank you, Mr. Moderator. Although the judiciary in Azerbaijan is by law expected to function as an independent branch of power, in practice such independence has never been realized since the country's independence from 1991. Judges are appointed by presidential decree, and the same ruling Aliyev family has held executive authority for nearly 3 decades. This institutional arrangement has transformed the courts into the extensions of the ruling regime as a political apparatus. Judges often side with investigators and other law enforcement agencies and approve requests to the extent pretrial detention, sometimes for as long as 18 months, especially in politically motivated cases. This denied people their rights to freedom and destroyed the idea that everyone is innocent until proven guilty. Government officials, including the head of the state, have repeatedly called people, mostly journalists, human rights defenders, and political opponents, criminals before any court verdicts, influencing trials and further damaging public confidence in justice. In politically sensitive cases, such as those involved online expression of peaceful dissent, no instance has been recorded where the court ruled in favor of the accused. The judiciary has thus become a mechanism of coercion. Beyond politically motivated prosecutions, corruption remained broadly applied across the justice system. Judges imagine in lower court reportedly received an official salary approximately 2,000 USD. This is too small, but if we look to their lifestyles, some of them live as like a rich oligarchs, as like a privileged class. Furthermore, the government has instituted a new mechanism of post-appointment review for new judges, new appointed judges. After 3 years in office, new judge may be reevaluated by Ministry of Justice, judge which is appointed by President, but after 3 years, his terms, he might be reevaluated by Ministry of Justice, which has the power to terminate his or her mandate via Justice Council. This system effectively eliminated independence, forcing judges to issue ruling favorable to authorities in order to retain their position. Without independent judiciary, justice in Azerbaijan will continue to serve as instrument of repression rather than protections, leaving citizens without trust or resource for fairness. I thank you.
Thank you. Next one is Tashkent SNOS.
My name is Farida Sharifulina. Группа Tashkent SNOS. Мы боремся против.
Our group fights against chaotic urbanization in Uzbekistan and enforced resettlement. Our legislation on urbanization is great, but it's not applied. Lately, the government took secret decisions about urbanization and city planning, which is forbidden. The Article 109 of the Constitution states that public hearings should take place. Secret decisions are not analyzed neither by Ministry of Justice or other bodies, which is required by the legislation. Also, the decisions are not published on the websites of state agencies and in the official legal database. That's why the government does not have access to information and cannot participate in public hearing. We cannot contest those decisions in the administrative court because we don't have the access to the text of the document. Quite often, people get to know about such decisions only at the stage when they start construction works in residential areas. For example, the president of Uzbekistan signed an order number 2025, which is only for internal use, about typical centers for Mahalit. This is so-called neighborhood quarter in Tashkent. So basically, they divided Tashkent in 500 communities. And also, this is like a municipality and a self-governing body, allegedly. So in the municipality, they're going to build some centers. So they're going to destroy and demolish the old ones and build the new ones. And one of the requirements of that secret order is as follows. The requirement of local population is needed, but there's been no hearing. And the mayor of Tashkent in July 2024 and in November took several decisions in order to implement those secret orders. About 100 municipalities out of 50 will be involved in the process. And local residents cannot protest, cannot appeal against the decisions. Similar situation took place in Samarkand, for example, in connection with the reconstruction of several buildings. For example, there was also another secret decree, and about 200 buildings were demolished, although they were part of a UNESCO protected area.
Thank you. Next one is Jangirich Initiative Group. Jangirich Initiative Group. If they're not present, we go ahead now to the Institute for Human Rights.
Thank you, Chair. We would like to draw the OSCE's attention to the ongoing and systematic erosion of judicial independence and fair trial guarantees in the Republic of Azerbaijan. The judiciary in Azerbaijan cannot be regarded as independent in either structure or practice. It operates under executive control, serving political objectives rather than the rule of law. As a result, more than 400 individuals are currently imprisoned on politically motivated charges. The right to a fair trial and public hearing enshrined in the Article 6 of the European Convention on Human Rights is routinely denied to journalists and human rights defenders. Rulings of the European Court of Human Rights are not only left unimplemented, but are systematically disregarded by domestic courts. Azerbaijan has become one of the leading states in Europe in terms of non-execution of ECHR judgments. Judicial proceedings often fail to observe convention norms, and ECHR precedents are persistently overlooked. Trials of political nature are increasingly held behind closed doors, particularly in the cases concerning alleged espionage or high treason. The cases of young researchers and peace advocates of, for example, Iqbal Abilov and Bahruz Samadov, who were sentenced to 18 years of imprisonment on fabricated charges, illustrate this trend. Journalists who attempt to cover such proceedings, including Ulvi Ali and Ahmet Mamedli, have been detained to silence independent reporting. Others face police summons and threats of arrest. Human rights defenders such as Anar Mammadli, Tofik Yogublu, Bakhtiar Hadjiyev, and Bashir Suleimanli continue to face repeated persecutions and lengthy sentences despite ECHR findings in their favor. This revolving door persecution underscores the absence of judicial independence and the systematic denial of fair trial rights in Azerbaijan. The erosion of judicial independence in Azerbaijan has transformed the courts into an instrument of repression rather than justice. Citizens cannot rely on the law to protect their rights, and political control over judges sustain a cycle of fear and impunity. The international community must press for transparent reports and accountability mechanisms to ensure that justice serves people and not the power. Thank you.
Thank you. Next one is Political Movement Group 24.
Здравствуйте, дамы и господа.
Good afternoon, ladies and gentlemen. I represent political movement Group 24. In Tajikistan, we don't have independent judicial power. All judges are appointed by dictator Rakhmonov, and they all depend on his will. This makes the system an instrument of political repression instead of a guarantor of safety. For example, a male who killed his wife only was sentenced to 9 years in custody, while the oppositionists have the and civil activists have sentences starting from 15 years to even whole life sentence. Along with that, there is another illustrative example of the corruption at the very top level. The former director of the Dushanbe airport was convicted of stealing of over $100 million. But people like that are protected by the system, so he evaded the accountability. The Group 24 supports Safar, who was abducted in Turkey and within the close proceeding was sentenced to 25 years. He was deprived of access to medical care and legal aid, while his only guilt was that he called for democracy. Such cases shows that the judges just cover the corruption. They serve for the people in power and not for the regular citizens. We call for a dependence of the international support over the judicial reform, because without the independence of judges, there can be no governance of law. Thank you for your attention.
Thank you. Next one is the Institute of European Law and Human Rights. Institute of European Law and Human Rights. If they are not present, we go ahead to the Turkmenistan Helsinki Foundation for Human Rights.
Спасибо.
Thank you. On October 23rd, there will be a court case of 2 bloggers, and it will take place in Ankara, in the Constitutional Court, that will decide whether they should be deported to Turkmenistan or not. Unfortunately, on July 24, they were actually released from the deportation center and they just disappeared. Was there a need to release them from the deportation center during the night? Their lawyer and the wife of one of them turned to the Turkish prosecutor's office, migration office, police, but they haven't been provided any information about the location of the bloggers. Some people say they've already been taken to Turkmenistan. So how can we talk about the rule of law? The Turkish law on foreigners and international protection, Article 4, states that no one cannot be sent to the country where he may be tortured or undergo ill or cruel treatment or punishment, or where his life can be threatened due to his religion, race, membership in in different groups or political opinions. Article 35 of the same Act states that if there's probability that a person may be tortured or may be sentenced to capital punishment, cannot be deported to the country where such threat exists. Where is the rule of law in this case? Recently, from Turkey, many people have been deported to Turkmenistan, the ones whose names I am saying now. Under the threat of deportation, there are other civil activists. The same situation takes place in Turkey in case of civil activists from Tajikistan and Uzbekistan. Mr. Erdogan, why do you let Turkey to be involved in the process? Do you want to be a co-participant in the crimes of the Turkmeni regime? The rule of law in Turkmenistan, I'd say, is practically non-existent. Thank you.
Ist International Community, internationale Politik für junge Profis.
Dear Ambassador, distinguished guests, my name is Anastasia Todoruk and I serve as the president of the NGO International Community. Thank you for the opportunity to intervene on the behalf of International Community NGO, a leading think tank to focus on shaping international policies through research, advocacy, and stakeholder engagement. Our work brings together diverse perspectives to create a meaningful change. The rule of law has been one of the driving principles of the OSCE mission since its establishment. Not only does it shape the human rights legislation, but it also affects the wider horizon of democratization and implementation of the good governance in the whole OSCE region. Nonetheless, over the most recent years, there has been a backlash on this front. The authoritarian drifts emerging in some countries are a reminder that the rule of law is the key to living in a democratic regime based on the human dignity, respect of minorities, tolerance, territorial integrity, and sovereignty, according to the international laws. Despite being one of the pillars of the democratic system, the rule of law is still perceived as an abstract entity by many people, especially the young one. Core democratic principles, which young generation feel distant from, even though directly impacted by them. Here is where the role of civil society organizations comes into the play. NGOs, especially those representing the younger generation, serve as a valuable platform, offering more and more individuals and groups prestigious insights and shared values, embodying the rule of law. This is our mission, engaging the young people so they can understand, appreciate, and spark the importance of living by laws and the values that lay underneath the rule of law. Given that, we call for supporting mechanism for independent NGOs engaging youth in democratic processes. Thank you for your attention.
Thank you. Next one is Turkmen independent journalist.
Dear ladies and gentlemen, dear moderator, the topic of my speech is the problems of Turkmenistan journalists abroad. For many years, I have been working with independent journalists, and on April 3rd, the special rapporteur called for Turkmenistan to investigate the attempt of poisoning the 75-year-old journalist. But despite the promises of the officials, she still cannot leave the country. I also want to share the story of Devlet Bahan, a journalist. We've been working together for many years on the materials about the violation of human rights. He was subjected to interrogations and threats by the special services, demanding from him to stop his profession. He was forced to escape the country with his family, but according to the agreement, he was extradited to Germany, although in 2025, the Augsburg court denied his application for political asylum. Now his family can be deported to the dictatorship Russia. This decision is concerning. He was sharing the truth about the violation of human rights in Turkmenistan for years, but now he's the one who needs protection. So I call for the international organizations and the officials of Germany to prevent the deportation of Rahman to his and his family. He deserves the protection of his life. We know that Turkey is a very dangerous place for Turkmen activists. That's what is observed in international reports. And the return to such countries cannot cost life. Thank you for your attention.
Thank you. Next one is the Karakalpak, branch of Uzbekistan Children and Families Support Association.
Спасибо, господин модератор. Уважаемые коллеги.
Thank you, Mr. Moderator. Dear colleagues, today I would like to tell briefly about the independence of court in Uzbekistan. Actually, this is a priority of the state policy. Recently, specific measures have been undertaken in line with the legislation. The basis for the court independence is a constitutional article, legislation norms, and the law on the judicial council, which makes a judicial body autonomous. The council impacts the nomination of judges, defines their qualifications and career paths. On the website of the Supreme Court, the majority of legislative acts pertaining to the judicial system are being published. It helps to improve access to justice. It's possible to register cases and get access to files via internet. It means that the judicial system in Uzbekistan has developed in a qualitative way. We need to protect judges from the external influence, to improve disciplinary methods, to implement digital methods. International organizations can support, for example, educational programs for judges, introduce mechanisms for the protection of judges, and safeguard the independence from the executive body. Also to promote international cooperation. We are interested in partnership with all parties interested in achieving this common goal.
Thank you. Next one is Switzerland.
Thank you. Martin Hemi from the Swiss delegation. Security, democracy, human rights, and rule of law are deeply interconnected. Durable security cannot exist without strong democratic institutions, and democracies cannot thrive in the absence of security. Parliamentarians play a vital role in this balance. They are not only the voice of the people, but they are also the defenders of democratic lawmaking. Crucially, they hold the executive to account, ensuring that power is exercised responsibly and in line with human rights and the rule of law. Open, inclusive, and transparent legislative processes reinforce parliamentary decisions' legitimacy and sustainability. Yet, in many parts of the world, we see an increasing tendency to bypass or accelerate legislative procedures in the name of efficiency or urgency. Such practices can erode the separation of powers, undermine parliamentary oversight, and may lead to exclusion and marginalization. In the long run, this creates vulnerabilities that internal and externals can exploit to destabilize societies and weaken trust in institutions. Defending democratic lawmaking is therefore not just about democracy, it's about security and stability. Mr. Moderator, Switzerland works closely with the parliaments of many countries, including Albania and Moldova. Through the exchange of best practices, training, and expert advice, these partnerships aim to strengthen parliamentary administration. The goal is simple, yet powerful, to improve skills, enhance services, and share solutions to common challenges. In doing so, parliaments become more resilient, more effective, and equipped with the proper tools for proper oversight. The work of ODIHR is doing to assist participating states in implementing their commitments on democratic lawmaking is of particular importance, including through its guidelines for making better laws. Similarly, the Council of Europe, notably the Venice Commission, and the Interparliamentary Union play central roles in protecting democratic resilience by offering expertise, fostering dialogue, and setting standards that help parliaments safeguard their independence and effectiveness. As Switzerland prepares for its upcoming OSCE chairpersonship, we want to strengthen the role of democratic institutions so that democracy, human rights, and the rule of law remain at the heart of European security. We aim to promote effective multilateralism by reinforcing collaboration between international organizations. Only by working together can we ensure that legislative processes remain open, accountable, and resilient in the face of current and future challenges. Thank you.
Thank you. Ladies and gentlemen, we have now come to the end of our speakers list, so I would like to thank you all for your disciplined approach, which leaves time now for more organizations to take the floor. We come now to our reserve list, and the first one I would like to invite to take the floor is the Noila Center for Social Support, Legal Promotion and Monitoring in Uzbekistan. Noila Center? Yes.
We're here. Good afternoon, dear moderator and participants. I am the head of the monitoring center of Noila in Uzbekistan. I want to highlight that many issues to be discussed today at this conference are of great importance. It's obvious that the development in democratic countries is based not only on the rights and freedoms of people, but also at the level of academic process, civil responsibility, and civil control. For prosecution of control and all forms of violence is important. For the past years in New Uzbekistan, the human rights defense and fighting the crimes as the forced labor and other issues has become a subject of public control. The great role here is played by the self-management, self-governance bodies of the Mahale region. This is the most close to the people chain of control, and they help prevent and solve social issues. As a representative of civil society in Uzbekistan, our center doesn't want to criticize anyone, but to share experience and learn best practices. Since 2024, our center has been conducting research in Vice Oblast region in terms of human rights defense. And we have also launched the initiative of Mahalin 7 that unites representatives of different sectors in order to increase prosperity for the citizens. We also would like to highlight the activity of bloggers, of media, who have been monitoring social processes along with the governance organs. Dear experts and human rights defenders, we are now living in the era full of contradictions and controversies. So it's so important now to enhance our cooperation, to learn experience of other countries. And in many regions of the world with limited resources, there is uncertainty for people's lives because of numerous conflicts. And there are unfortunately, the role of international organization in solving such crises is decreasing now, but we are eager to enhance our cooperation in terms of human rights defense. Thank you for your support and attention.
Thank you. Next one is ADF International. ADF International? If not, we go ahead to Gizilbash Youth Education Public Union.
Ladies and gentlemen, Armenian NGOs lie and manipulate, and they should be the last ones to talk about the independence of the judicial system. The judicial system in Armenia is corrupt, it's not independent, and it's not trusted by the society. They disseminate false accusations, and the Armenian NGOs should remember about numerous crimes committed by Armenia during the conflict. They expelled many people. The statements that Azerbaijan conceals information about some hostages just due to their ethnic identity is also false. The working group and the UN Human Rights Council on arbitrary detentions, in his report actually wrote about the smear campaigns connected to the arrest of Vardanyan. International bodies also did not identify any grounds to satisfy Armenian claims. We appeal to the Finnish chairmanship to make sure that Armenian NGOs do not use this platform to disseminate disinformation and justify former violations by its country of the fundamental principles and like respect of territorial integrity and the borders of the country in line with the Helsinki document. Thank you.
Thank you. Next one is the Islamic Renaissance Party of Tajikistan.
Уважаемые коллеги, дамы и господа.
Dear ladies and gentlemen, dear colleagues, I'm Mirza Karim Kuzov, the Islamic revival of Tajikistan. After Emomali Rahmon came to power in 1992 as a result of Russian special operation in Tajikistan, the people began calling the Tajik court Gov Sud. Gov is the Tajik word for cow, sharing. Why have the Tajik people dubbed the Rahmon regime's court cow courts? Because a cow is controlled by a shepherd's stick and always follows a predetermined route. Neither a right nor left. A court's decision in modern Tajikistan does not depend on evidence or debate. To paraphrase a Russian gem by former Duma Speaker Grizlov, a Tajik court is not a place for debate or discussion. In this sense, a Tajik court is the most independent from society, from citizens. The most high-profile trials take place without witnesses, without the press, without relatives, on the premises of a state committee for national security prison. Relatives and journalists sometimes have difficulty finding out the name of the regime-appointed lawyer. Lawyers refuse interviews even if their cases are not classified. Following the massacre of the fearless lawyers Buzurg Meh Yorov, who was sentenced to 28 years for his professional activities on chopped-up charges, and several other respected lawyers, and the suspicious death of lawyer Faiziniso Vohidova in hospital, the remaining lawyers in Tajikistan have been relegated to the ranks of Emomali Rahmon's regime and deprived of the power of speech. They say everyone creates their own world, their own structure, and their own image and likeness. One sewing machine part can only assemble a Kalashnikov assault rifle, while another creates a barnyard and builds stalls for people. Sometimes they meet to exchange experiences, as they do these days in Dushanbe. I would recommend that OECD countries and human rights organizations not forget the need to protect and support lawyers in Tajikistan and the work of Tajik lawyers and journalists who are political emigres in Europe. Thank you for your attention.
Thank you. Next one is NGO Central Asian Progress and Integration Forum.
Dear conference participants, ladies and gentlemen, as we know, after Mirziyoyev's coming to authority, Uzbekistan has entered a period of large-scale reforms aimed at a democratization of the state and society. In this process, human rights have received new momentum due to some following factors. Firstly, the political paradigm has changed. The state is paying increased attention to openness to international human rights standards, as well as to improving the country's image on the international stage. Secondly, the legislative reforms have been implemented, a number of restrictive norms have been abolished, and new laws have been adopted on the freedom of assembly, such as the activities of NGOs is freely created, and the media and the protection of citizens' rights. Thirdly, there has been a growth in civic activity. Public organizations, initiative groups, and volunteers are actively involved in the monitoring the observance of human rights. And the main areas of the human rights have been focused, including providing free legal aid to vulnerable groups of the population, monitoring the observance of the rights and interests of various special groups, such as women, youth, persons with disabilities, prisoners, and other at-risk categories, legal education, and raising the level of the legal awareness. Today, hundreds of non-governmental, non-profit organizations are operating in Uzbekistan, freely determining their activity areas. Among them, we can count the Bar of Association, Societies of Persons with Disabilities, Societies of the Blind and Deaf, the Freedom of Trade Union, and Association for Consumer Rights Protection, and other NGOs, and including our organization too. The most important mechanisms of the human rights actively are public oversight, legal education, and international cooperation. And a key role in this area is played by the law of public oversight, which defines its types and forms, indeed, and a new institutional reforms have been carried out, such as all law enforcement agencies have units dedicated to human rights observance, and a human rights department have been established under the Ministry of Justice.
May
The
I
Ombudsman...
ask you to wrap up, please?
Sorry. Oh. And we can ensure that all categories and every citizen is granted right to advocacy and free trial.
Thank you very much. Next one is activist Kakamurat Khudyrov.
Thank you very much, Mr. Chairperson, esteemed colleagues as well. Let me speak by Russian language, because yesterday I spoke by English. I think it's our colleagues not fully understand me. So,
dear colleagues, dear moderator, I today listened to my colleague from Finland who said a very important thing about the open platform which actually involved Ukraine. It also involved Uzbekistan. And I was so happy. I would like other countries to get involved with that open platform, including other Central Asian and post-Soviet countries. Why am I speaking about this? It's not a secret today. Turkmenistan has the worst dictatorship in the whole Central Asia. Turkmeni people are being tortured and repressed. We cannot move freely within the country. We do not have access to OSCE mission in Ashgabat. That's why I would like to suggest, this is not just my suggestion, this comes from our people. They said, please organize a transparency day in OSCE when representative of the OSCE mission in Ashgabat, or maybe colleagues from other countries, will be present. And at that meeting, human defenders and OSCE mission can share information about their work. They can ask questions to each other. They can come to consensus to develop a methodology, an approach to fighting for human rights. I'll just give a few comments. I visited the website of Ashgabat OSCE mission. They say, fight with terrorism. This is where actually all hunting guns have been confiscated. And they also want to fight trafficking in people. We cannot freely move within the country. The rule of law, this is just pure rhetoric. And this is what OSCE mission is writing. They're basically laughing at common people. I can keep talking, but I think the cherry on the top is the section human rights. Let me quote. The center regularly organizes seminars and training programs on human rights for employees of judicial and law enforcement bodies in order to introduce international human rights standards and OSCE commitments. So I'd like to ask you, what is your success so far? It's like you get together predators and tell them it's very bad to eat meat, just eat grass.
Mr. Chairperson, thank you for your patience. Thank you.
Thank you. Next one is Tajik Youth for the Revival of Tajikistan.
Thank you, Mr. Moderator. My name is Ubaidullah Saidi. I am the leader of Tajik Youth for the Revival of Tajikistan. I represent a generation that believe the rule of law is not just a legal idea. It is the foundation of freedom, dignity, and the future of our country. In Tajikistan, the words justice, law, and democracy are often used by those in power. However, behind those words, the trust is different. The independence of the judiciary has been replaced by loyalty to one person, one family, and one system. Courts no longer protect citizens, they protect the regime. And when judges fear the government more than they respect the law, justice disappears. The right to a fair trial is a dream for many in my country. Lawyers who defend political prisoners are threatened or jailed. Journalists and activists are punished not for crimes, but for their telling the truth. Ordinary people are afraid to speak because the law does not defend them. It uses against them. Right now, as I speak here, President Vladimir Putin and other leaders are visiting Tajikistan. This visit is present as a celebration of friendship and corruption, but it is also raises serious question. Tajikistan is a member of an international criminal court, and President Vladimir Putin is under an ICC arrest warrant for alleged war crimes. Yet the regime welcomed him with a honor. What message does this send out to our people, to our human rights organizations and democracy countries? That international law can be ignored when it is politically convenient? I ask all of you how we could not take any serious steps to sanction the regime of Emomali Rahmon in Tajikistan. Still, I believe in hope. Across Tajikistan, from Dushanbe to Khorugh, young people are not giving up. They still believe that law can serve people, not poor. The trust can overcome fear, that our country can rise again through justice, not operation. I call all organizations and all partners to use their influence wisely to engage with Tajikistan, not only on trade or security, but on human rights, fair justice, and the rule of law. Only they can cooperation bring real stability. A stability built the trust, not fair. Thank you for your attention.
Thank you. Next one is National Alliance of Professional Social Workers.
Thank you very much for possibility to speak out today, and good day for everyone, Chairperson. I would like to highlight some experience of the contribution of civil society organization in my country, in Kazakhstan. I am head of National Alliance of Professional Social Workers. First of all, I would like to stress on the third dimension of this topic, and one of example is I was invited as a member of professional council under Senate of Republic Kazakhstan to provide consulting, provide pedagogical approach, etc. And was of the example that I was the mentor of the second wave of analytic school. It was established under Senate of Kazakhstan. Now we had five waves of Elise school, and I was the head of the report, which is called Inclusion and Socializations and Education and Labor Peoples with Inclusion. And it's available on the site of Senate of the Kazakhstan. And because it was nice, great example, and I was also mentoring the second wave of school, and we did a report about a social workforce for for Kazakh legal reform, which is also was great as an example of democratization. Like we had a possibility to be not voiceless, to provide our voice and make it louder. Another example is that also during last 2 years, I was a member of the working group and the parliament, Majlis, and another. We have two parts of Senate and Majlis in Kazakhstan. It was a law about domestic violence and a law about the professional families. But for my professional opinion, that each legal reform, we need to have a human capital to capable to do such legal reforms. And this is why we should provide consulting for our members of parliament. And we're doing quite good in that. But same time, there is a big challenge that professional associations should be very professional to be enabled to provide and to do, because it's very hard work with several hours to work and to be inside and to work hardly with paper. Another example that we also, because I'm also teaching social work in Eurasian National University, we had example 7 years ago to do a MA program in social work and justice. And this is also good recommendation which I'm providing the last several years to enhance our system of court to be also to be fruitful and to develop social work in court social work, because I have learned from several countries that they have. Fine. They having a court social work association, and we are trying to contribute and to follow up with our recommendation to our parliament in Kazakhstan. Thank you very much.
Thank you. Next one is Atajurt Party.
Здравствуйте. Hello. Thank you for giving me a chance to speak. I represent non-registered Atajurt Party. I would like to attract OSCE attention to the critical situation in Kazakhstan. We talk about the independent judicial system today. Independent court is the foundation of a democratic state. It ensures the rule of law. Unfortunately, judicial system in Kazakhstan is actually dominated by the executive power. Actually, all branches of power, including mass media, are controlled by the president. He appoints the judges, the prosecutors, the ministers. None of the branches is independent. Judges in Kazakhstan do not follow the law, constitution, or any international agreements signed by Kazakhstan. They only follow the orders from above. Marat Filanbayev, a politician, a leader of one of the parties, was sentenced to 7 years in closed proceedings. He actually was on hunger strike for over 200 days. His health condition is really bad. Although we've appealed many times to release him, the president has ignored us. Ombudsman nominated by the president disseminates false information about his health, saying that he feels well. Marat actually, through his lawyer, informed us about tortures and bad conditions. Another journalist was sentenced to 7 years as a result of the closed trial. Another human rights defender was sentenced to 5 years in imprisonment. We have dozens of such cases. All proceedings are closed without the access for journalists, human rights activists. All the sentences are ruled in line with the orders from above. This is actually the way to fight the dissent. The human rights situation and the state of the judicial system causes great concern. We appeal OSCE countries to visit political trials, to visit political prisoners, to verify their health condition themselves, to actually demand from the regime to release immediately all political prisoners. In Kazakhstan, authorities are afraid of the truth and justice. That's why they keep in isolation those who keep the truth. Please, international organizations, don't stay silent. Please make them to follow international agreements and human rights obligations.
Thank you. Next one is Cultural and Educational Association of Roma Women of Drozero Xanthi, The Hope. Once again, Cultural and Educational Association of Roma Women of Drozero Xanthi, The Hope. Nobody here. May I just ask also from here seen to the left side to extinguish the microphone there? Thank you very much. So, next one is then the Democratic Party of Alga, Kazakhstan.
Здравствуйте.
Thank you very much. I am the member of the initiative group to create an opposition party in Kazakhstan. I would like to draw attention of the countries of OSCE to systematic violation of rights in Kazakhstan. The judiciary in Kazakhstan is totally controlled by Tokayev. All court proceedings are conducted in the interests of the regime. This system fulfills the orders and suppresses civil society. Any dissent is seen as criminal, as crime. In July this year, a wife of political prisoner Tokayev was convicted to 2 years of imprisonment for just defending rights of her husband. In March 24, the verdict was adopted against Bagdagul Andreev, Gershan Turuev, of 6 years of imprisonment. Here is the list of other people convicted to 5 years of imprisonment. They were accused of preparing for coup d'etat. However, no facts confirming these charges were not presented. All evidence of defense were ignored. These are just peaceful citizens, activists, not criminals. We see, based on this example, that the rights of citizens to fair trial is being violated. People have no possibility to protect themselves in the courts and count on fair trial. I would like to call to countries OSCE participating states to pay attention to the political processes in Kazakhstan, attend the court proceedings as observers. Thank you very much.
Next one is Barkayror Hayot, Sustainable Life. Barkayror Hayot, Sustainable Life. No one here. So then we go ahead to the Dayanch Civil Movement Platform.
Уважаемые коллеги,
Dear colleagues, torture in Kyrgyzstan is not an exclusion but a consistent practice. It's used in detention centers and prisons as a method of intimidation. Abdullah Urusov and Alisher Sadov are the living example of the crimes against humanity. They were abducted with the help of Turkish special services despite the pact against torture. Now, while we're talking, they are being tortured. There are 4 kids, and the wife of Alisher are now living in the atmosphere of uncertainty and fear. If the world is silent today, the same will happen to female human rights defenders. They are the mothers of little children, but they are kept in custody. Diana Dadasheva is a key figure of the human rights defense movement in our country. Those women are the symbol of resistance to dictatorship. Turkmenistan has signed the Convention Against Torture, but they decorate those who committed that torture. There are crimes and abductions abroad, and fear is the main tool for the people in power. There are families that live without their breadwinners. We call for immediate release of Alisher Sagatov and Abdullah Yusuf. We call for creating the international mission for inspection of Turkmen prisons, for imposing sanctions on those accountable for torture and abductions, for ensuring defense for Diana Dadasheva and Zarina Aktayeva, for providing them the green corridor and international support. The Dayan Civil Movement Platform, along with the Argo International Organization, are already documenting the torture and providing legal aid to the victims. This is our step towards the protection of human rights. And right now, while listening to this, Abdullah Urusov and Alisher Saratov are being tortured, and the silence of international community makes them the accomplice in this crime. Thank you for your attention.
Thank you. Next one is the delegation of Uzbekistan.
Здравствуйте, уважаемые.
Good morning, dear conference participants. It's important to stress that judicial reforms that have taken place recently have improved the independence of the judiciary, but also improved the access to the courts and provided grounds for better protection of interests of citizens and businessmen. We had a presidential decree on the reformation of the judicial system and improvement of the access to the judiciary system. A short-time strategy was developed aimed at raising the judiciary system to a higher level of quality. To undertake measures to improve the independence of the judiciary, to introduce investigations in cases when judicial rights are limited. Such investigations will be possible only on the basis of the prosecutor's decision. At each stages of the trial, the principle of the equality of the parties should be introduced. Also, we need to increase the number of women judges. Now we have 15% of women judges, and in the Supreme Court, 19% of women judges. Everyone knows that in today's world, digitalization of the judiciary is really important as a safeguard of transparency and accessibility, and the way to increase the trust of the population to the judiciary. So it's possible to apply to the court online. It's possible to watch trials. It's possible to pay fines. Also, judicial judgments are published online. Documents are being referred for execution also in an electronic way. IT technologies have been implemented in the judicial system, and now the Supreme Court works on the implementation of the digital court, and we will stop using papers, and everything will happen in a digital way. And also, it will be possible for citizens to evaluate the success of their case based on the introduced criteria in advance. Thank you very much.
Next one is Azerbaijan.
Thank you, Mr. Ambassador. Azerbaijan attaches utmost importance to the principle of the rule of law, judicial independence, and the right to a fair trial. As international experience demonstrates, reforms in this field are of continuous process. Our country, too, has undertaken consistent actions aimed at the ongoing development of its judicial system. These reforms have been highly commended internationally. For instance, the selection procedure of judges received a high assessment from the international organizations, while Azerbaijan is known for the effective application of information technologies in courts. At present, one of the main tasks in the field of justice is to restore and efficiently organize judicial institutions in the territories liberated from occupation, where massive reconstruction and infrastructure works are underway. Mr. Moderator, some individuals here seem to prefer putting cameras in front of themselves and turning human rights into a kind of show. They repeat the same baseless stories again, sometimes even claiming that judges in Azerbaijan are very rich. I cannot say how rich they are. I didn't count their money, but I can definitely say that the government of Azerbaijan continues its systematic work to reduce the poverty in the country, and the results speak for themselves. Poverty has been reduced seriously. It is nearly 5% today. It's also telling that some NGOs that try to criticize Azerbaijan has never spoken before about the massive human rights violation committed against Azerbaijanis during the years of conflict. Nor do they address serious human rights issues in their countries of residence or immediate neighborhood. This selective silence brings me to a conclusion that in most cases their actions are politically motivated rather than driven by genuine concern for human rights. When it comes to the unfounded allegations against Azerbaijan on the issue of Armenian detainees, our civil society organizations have spoken about it enough. I want to just outline that probably we will consider distributing the full text of our statement, which will reflect our arguments on these allegations as well. Thank you.
Thank you. Ladies and gentlemen, this brings us to an end of today's interventions by participating states and civil society organizations. I'd like to thank all the speakers for their contributions, for their emotion, for their cause they are fighting for, and also to the participating states for their insightful contributions. Hence, now I would like to give back the floor to our introducers, and I'd like to start with Judge Guglielmi, please.
Thank you very much, and I would like to thank all participants for their contributions. They outline the complexity of the challenges facing the rule of law and fundamental rights across different national contexts and dimensions. Justice, its independence and accountability remain at the heart of all these challenges, both at the national and supranational level. Justice is vulnerable. and the risks and attacks against independent courts and their role as impartial guarantors of rights and freedoms caused by the erosion of democracy are amplified by many other factors, such as artificial intelligence, that can be a powerful tool for undermining civic participations, supporting discriminatory practices, and can also be used to influence court rulings. So the challenges are complex, and our task is complex to support the resilience of independent justice, and a democratic rule of law requires joint and active commitment from a range of actors and the protection of all components of independent justice, not just an independent statute for judges and prosecutors, access to justice, particularly for the most vulnerable people, and fair trial require, for instance, independent lawyers and the defense of their role and the role of their professional associations, today increasingly and seriously under attack in upholding the rule of law and safeguarding human rights and fundamental freedoms. The resilience of international justice system requires today the protection not only of the role of judges and prosecutors, but also of human rights experts and civil society which cooperate with international justice. And as recent experiences of democratic regression in Europe has shown us, the resilience of independent justice and democracy has among its key components an active role on the part of civil society. Resilience of justice requires active citizens aware of the value and importance of judicial independence, which is not a privilege for judges, but a guarantee for individuals for their equality and their protection against any arbitrariness. And in this regard, the role of the Council for the Judiciary is an essential one. Councils must show, as the European Network of Council for the Judiciary recently stressed, must show leadership and courage. They must act without delay, use all the means at their disposal in the context of democratic regression, and speaking on behalf of the judiciary, engaging in frequent and regular dialogue with civil society, the media, and public at large, as stressed by the ODIHR Warsaw recommendations. Judicial associations can play as well a crucial role in dialogue with civil society and in public debate. They have, as do individual judges and prosecutors, both the Strasbourg Court and several international documents, and OEC and ODIHR opinions in 2021 clearly stressed they have the duty to speak out when the rule of law is at risk. So the resilience of independent justice requires training of the judiciary, instilling the understanding among the judicial corps that the rule of law entails main elements beyond the legality of law. And for that, I would like to conclude by emphasizing the great value also in this perspective of the opinions, recommendations, and all the initiatives of the OSCE and ODIHR in order to promote democracy, rule of law, and human rights, and support open dialogue between all those committed to defending these values. Thank you.
Thank you very much, Mrs. Blacks.
Thank you also on my behalf of all the speakers of the day. It clearly shows how well, particularly the part of the independence of judiciary and a fair trial, access to trial, sort of rights and procedural methods are known around the table and that they are appreciated. I would like to continue from that perspective I started, and first of all thank and hence to the guidelines of democratic lawmaking for better laws written by OSCE and ODIHR, and some of the things I referred were also included there. But if I go back to this sort of playbook of an authoritarian policies or playbook of very corrupted leaders, to make shortcuts in open society, be it then the rights or procedures in the court system or in lawmaking, you quite effectively nowadays use labeling labeling courts for example, being elitistic, not understanding the needs of the people, labeling academias being whether too liberal or too just sort of a people that play with taxpayers' money and don't really do the research in a proper way but ask dangerous or stupid questions. I think that it's very relevant in these circumstances to remember that like we have the procedural methods to safeguard the independence of courts, for example, when it comes to nomination processes of judges, we likewise have also some procedural methods to guarantee or test whether an academia or a journalist or an NGO can be regarded as independent and not corrupted or taking sides, be it political, religious. So I just hence to the academic world that we do have very strict, long-standing rules of institutionalized disciplinary autonomy, peer review, and the self-government of the universities. In the journalism, we have long list of principles of journalism. And then when it comes to NGOs, the openness when it comes to funding and the backgrounds of the NGOs are guarantees to fight against this labeling of these very, very crucial parts of the rule of law being just part of a political debate or being corrupted or being somehow doing something that gives a reason for an authoritarian regime just to walk over, to ignore and tell to the people that we cannot afford these processes where true evidence-based decision-making is needed. So from that perspective, it sounded also really good what the next presidency, Switzerland, has in mind, that also safeguarding the democratic institutions and their work will be touched upon. That might give an opportunity also to come back to this evidence-based decision-making and the academia, journalists and NGOs. Thank you.
Thank you very much. And last but not least, Judge Kovacheva, please.
Thank you very much. It was both an honor and a pleasure for me to address this distinguished assembly on a topic that stays in the very heart of the rule of law of our democratic societies, and this is the independence of judiciary and the independence of each judge. Without this independence, the promise of justice becomes fragile, the protection of rights becomes illusory, and the trust of citizens in the administration of justice is irreparably weakened. I have started my presentation by saying that the judicial independence has long been considered as a general principle of law recognized by civilized nations. And I want to say this again, because independence is not an end to itself, not an end in itself. It is an instrumental value which actually enables courts to safeguard the rule of law and the human rights. I recently read somewhere that you are free if in your life you do not need a security because it is there. It is a conditio sine qua non. And this reminded me about the old debate whether we need more human rights or more security. And every time when this debate is on the table, I think rule of law and independence of judiciary is in danger. Let's not do it. Thank you very much.
Excellent concluding words, Judge. Thank you very much. I think that's very well fitting. Ladies and gentlemen, now, just before leaving you into the lunch break, I have to inform that Turkey will submit a right of reply. I'd like to invite participants to the next side events in the afternoon starting at 14:30. The program you will see on the website. Furthermore, and I think that's interesting for the ones who stay for the weekend, the Polin Museum of the Museum of the History of the Polish Jews has offered free admissions for all conference participants on weekends, Saturday, Sunday. You just bring along your badges. Ladies and gentlemen, thanks a lot. I'd like to thank the Finnish chairpersonship and especially Odir for providing us with expertise and organization, and I wish you a nice Friday. The session is closed.